Okay, good morning again. I think all our technology is working this morning and we don't need to communicate with any of the booths. Thank you everyone for your patience yesterday as we bounced around. It was new to have a booth 4 or a booth 5, and some of the technology I used to turn the speakers on and off only went to booth 3. So we had to develop some workarounds. We have a trial calendar that I'm calling today. It reflects sort of 1.5 trial calendars. There are 3 weeks that we may have criminal trials over the next 4 or 5 weeks. Monday, we'll start a trial. That's the 9th. Ideally, we'll also be able to start one on the 23rd. That's that surprise supplemental week, pleasant surprise. But we've always also had the week of the 30th. I had specially set a case for Monday, and I had specially set a case, meaning the 9th, and one for the 30th, both involving Mr. Johnson. I didn't realize that Mr. Johnson was one of the chosen few who is on the YSL case. And as of last night, he's still on it and his client is still in it. And so those 2 special settings, at a minimum, Mr. Peck, which was specially set for Monday the 9th, we can't go forward on. I see Ms. Charles here. And I hope you didn't spend too much time getting extra super ready, but we don't have a Mr. Johnson to move forward with Mr. Peck's case. I have inquired of the GPDC if they might be able to identify a colleague of Mr. Johnson's who could assist not with trials, but there are a number of his cases that are either from the mouth of the defendant, we heard yesterday, or from some of the prosecutors, real close to a negotiated resolution. And it seems like a partnership with another colleague from the Metro Alternative Defenders Office might yield resolutions there. So there may be a couple cases on this trial calendar, as well as Mr. Holt, that we could resolve by having a colleague of Mr. Johnson's parachute in. And I'll hear back today from GPDC about that. I didn't say, hey, you need to find someone to try a case, although poor Ms. Boyd, I can't even arraign her today. And I don't know what exactly has changed in the indictment other than in classic gang unit format is longer. But we still need to work through that case, and she's on her 6th lawyer. Not her fault at all, but that's not one where I think it's appropriate to say you need to find a different lawyer for Mr. Johnson. I don't know if he's connected with her yet, nor do I know that someone parachuting in could be ready for trial, even if it were the week of the 30th. So if you are here as a family member, a defendant, a prosecutor, in connection with a case that Eric Johnson is handling, we cannot try any of them, but we may be able to resolve some of them. And I'm going to hopefully be able to connect with him to see if there were others that he knew were close to resolving. But again, one client has let me know it's close to resolving. And then a couple of prosecutors have said, look, we could sort this out if we literally had a lawyer to talk to on the other side. So you've been standing very patiently, Ms. Charles.
With regards to Jerry Peck, the victim in that case is in custody at the Manual facility. I spoke with Ms. Nelson since last year to do a production order for us to bring this today. I want to confirm if she hadn't got over.
She's at the what facility?
Manual facility in Swansboro.
Okay, is that a DOC facility? Department of Corrections or?
It is.
It is, okay. I don't know if she's here.
I'll have to look.
We'll check. We'll check. So let me call the calendar. I'm going to call Mr. Johnson's cases as well, because again, there could be family members here, defendant clients here, and we'll work through that. But I just wanted to manage expectations if people were here to get excited about how one of Mr. Johnson's cases would be going to trial on this set of weeks, it doesn't seem likely. Now, I'm not taking Williams and Tolbert off because it is possible that a couple more days of jury selection will cause a few more YSL defendants to plead. And if Mr. Johnson is no longer obligated in front of Judge Glanville by the middle of next week, I would expect him to be ready with Mr. Tolbert. I trust Mr. Williams is ready to go, and I'm confident that someone from Major Case will be ready to go on Tolbert and Williams. I think Mr. Abate has another case he'll be trying that week, but they'll line someone up. So that'll be one where folks should stay in touch, but far enough in advance, I'll say stop preparing for that one because it just wouldn't be realistic to expect Mr. Johnson to pivot from YSL if he rolled off it 3 weeks from now. So we'll see. It complicates planning. All right, with that, position 1 on the trial calendar is not one of Mr. Johnson's cases. It's Mr. Beard. I see Mr. Beard here. Ms. Feely, are you ready on Mr. Beard's case? All right. And Ms. Ockham, how are you?
Good morning, Judge.
Happy New Year. Are you ready?
Yes.
Okay. Ms. Feely, we didn't have the usual kind of meeting where just because of where we are in the new year to talk about just some procedural things. So I would know which weeks are better or worse. So we'll do that now. We don't have anything to try next week. What is the best of the 3 weeks for you in Mr. Beard's case? And if part of the answer is, hey, it depends on the other things you decide, you also have a chance here to say, I can be ready on these various things. I would prefer that X go out, and then I'll get the same input from the state. And then at some point today, I'll send an email out to all counsel saying, this is what I foresee next week looking like the 23rd and the 30th.
So my thought would be the 23rd, because I think this is going to go into next week, and next week would be, we wouldn't be able to bring the jury back till Tuesday.
Mr. Beard's case would take more than 1 week. Okay. And because there's a Monday holiday in there somewhere.
Right.
Oh, this next Monday is a holiday. Got it. So for timing reasons, as in duration of trial, you think the 23rd is better for Mr. Beard?
I think so.
Okay. Ms. Ockham, what's your schedule?
I'm ready.
Okay. Any reason we couldn't do it on the 23rd? What does your computer say?
I would be fine on 23rd.
Okay. Do you share Ms. Feely's perspective as to how long? We'll pick a jury on Monday. So the 9th is jury selection. We'll be rolling on the 10th with the state's presentation. Do you think, and I trust there's a defense, I remember this case. This is a retrial, so I know a little bit about the supposed facts. How long do you think the case would take to try?
The state believes it will take a week, and that's because we have to go through testimony, and then if the defense has to question them all the prior, so we testify at trial and motion,
Okay.
all of that. But I think excluding jury selections, we should take 4 days.
Okay, but it could spill over, and then that would get us to a Tuesday, and that's only like a half day for me, and then I turn into a pumpkin. I have to be reprogrammed at the CJE session that week, and you don't want me to go unreprogrammed. So that may make the 23rd a better fit, although it may make the 30th a better fit, because that's a week where if we spill over, we don't run into another trial week. All right. How do you look on the 30th?
I'm ready to.
I know you're ready. I heard that, but you also have to be in lots of courtrooms. You're available. This got to be the oldest. Well, are you in cold case?
Yes.
So I can't say this is the oldest case you have, but it needs to be on the list somewhere higher up. It's 2014 indictment. But anyway, you'd be available on the 30th?
Yes.
All right. Mr. Beard, you doing okay?
Yes, sir. No.
All right. All right. I will factor all that in. Thank you. Do you need Mr. Beard to stay here?
Stick around.
Great. So I need you to sit tight. Ms. Feely wants to chat with you. When she says you're good to go, you don't need to hear from me again, okay?
No, that made me, I didn't see that, but let's.
Is this your only case?
Yes.
Yes, ma'am. You'll get an email along with all the other lawyers mapping out how I think we'll do those 3 weeks. All right. Mr. Peck is the next 3 positions. I don't know if there's anyone here besides Ms. Charles for Mr. Peck. All right. What we'll do, Ms. Charles, is figure out if you just get that name of the individual you're hoping to meet with today to Ms. Nelson so that she can make an inquiry as to whether she's here. And we'll make sure. Oh, is the last name Price?
Yes.
She is here. She's downstairs, but we'll make sure that at a time that makes sense for the deputy, she gets brought up. I think a bunch of folks can go down after I call the calendar because they're Mr. Johnson's clients. And so there's no one to go back to say, hey, maybe we could work the case out. So if you're welcome to stay, or you could come back in 15, 20 minutes and we'll get Ms. Price up. Okay, great. Christopher James is positions 5, 6, and 7. Mr. Byrne, good morning. You represent Mr. James on the surface, what looks like the most serious case. And then is Ms. Roberts here? Hi, Ms. Roberts.
Good morning, Your Honor.
Good morning. Ms. Roberts represents Mr. James on the other 2 cases, although Mr. Jordan mentioned yesterday and let me know that this may be working out, that there could be a 4th case. Or am I misremembering?
Yes, there is, Your Honor.
There is.
CP case on the United States.
Okay.
I spoke to the state yesterday. We're potentially maybe do a waiver arraignment and
Handle the 4th case. Okay.
resolution.
Mr. Whitenauer, you have which of the cases?
4th case, it's a DD, not on this calendar.
Oh, so the CP case is yours, and Mr. Jordan, you've got these 3.
Your Honor, I believe it actually may be 5 cases. There's 3 cases that are on the calendar, the 4th unindicted matter, and then 88 Wettenauer's 5th case, which is not on the calendar today.
Okay. CP cases wouldn't be on the trial calendar. That's right. But I also understand the desire of Mr. James to wrap everything up rather than I plead out to one and then later on I plead out to another. Let me start with Mr. Byrne, because my understanding is if that we were going to try Mr. James's cases, we would start with position 6, which is the one Mr. Byrne has. Are you ready to go? And if so, which of the weeks works best for you?
I'll start with the second question.
Sure.
Which 2 weeks are better for me? It would be the 23rd and the 30th.
Okay. Because?
Because 2 reasons. Number one, I have plans to be out of town on the 13th,
Okay.
Friday.
All right.
And number 2, I think that the parties need this time between now and the 23rd to get together for the public defender to get a copy of the discovery on the new case and to determine whether we can reach a global settlement. That is going to take time, and I think the time between now and the 23rd will be the time we need.
How long are you gone if you disappear on the 13th?
Just the 13th.
Oh, okay.
But I'm also scheduled for a trial in U.S. District Court starting the 17th.
Okay. Then what would happen? So what we tend not to do on the day of jury selection is take pleas. So if we put Mr. James, let's just say hypothetically on the 23rd, and I were to say first out because he's been in jail for almost 800 days, then your case would be first out on the 23rd, but we couldn't do that because you're going to be in trial in front of Judge so-and-so and
starting on the 17th, but I don't expect, that's a Tuesday, that's the day after.
Yeah.
Okay, but I don't expect that trial to go longer than 4 days.
Okay, so you'd be done in federal court. You could be here on the 23rd for a trial, but if Mr. James is going to be a plea because the 4-part negotiations plus Mr. James yield something, how do we get you here for a plea that's not going to make us late in starting jury selection on the 23rd with a different case because we're not trying Mr. James?
The only thing I can think of is to do it on the Friday before.
Okay, and so we'd just be keeping in touch with you to see how quickly the Boulay trial is going. Are you is your client the only defendant in that case?
Correct. Yes.
And what are the charges?
21-841, 21-846, and 924.
Okay. I don't know, that'll even be 4 days. I do, right. And so that may be a day of jury selection and then a day of what should have been a suppression hearing, but maybe it's more complicated.
Jury selection will take about an hour.
Yeah, those were the days.
And the trial won't be very long.
Okay, got it. Ms. Robert, tell me what works for you. Do you agree that if we, one, it doesn't sound like you'd be going to trial, it would be Mr. Byrne, at least first, but does deferring resolution of Mr. James's case till just before the 23rd work for you, or what's your schedule?
Absolutely.
Okay. And would you be willing to take responsibility for negotiating the 2 unindicted cases?
Well, actually, Your Honor, there's only one indicted case, and I have essentially took over that case. So I actually have 4 cases. So I have 3, and then I have the unindicted case.
Okay, I'm confused then. So you have, I have 3 indicted cases for Mr. James.
It's just that the case, the last time I was before you, which I believe was on November 2nd, that was the case that you wanted me to, we were talking about filing a waiver, doing a waiver of arraignment.
Yeah.
So that was filed on November 2nd.
Oh, so you already filed an entry in that case?
Yes. So that case is actually not on this calendar, so that's why you don't see it. So
Right.
absent that 107 being on this calendar is actually literally 4 on here.
Okay,
And then the unindicted case, the CP case. So I'm gonna take the CP case, so those 4 cases are mine.
got it. You'll cover everything else. All right, understood. So I may be misunderstanding. There is another indicted case. It's actually bent or accused.
Yes, that's just not on this calendar.
Okay. So when you were referring yesterday, just procedurally, Mr. Jordan, that there was this unindicted case, you're actually were thinking of what we're going to call Mr. Whitenauer's case, or did you not know that Ms. Roberts' 3rd case had actually been formally accused or indicted?
No, Your Honor, there's a separate case, 88 Wettenauer's cases is indicted, that's not on the calendar today. He has the 3 cases that are on the calendar today, which are the possession with intent to distribute, the possession case, and Attorney Burns' case. And then Ms. Roberts yesterday informed me that he has an unindicted matter.
Got it.
In which I sent her discovery
So,
yesterday.
Mr. Whitenauer, your case is indicted.
It is, it's 22 SC 184-107, and discovery's been served. I understand there's some issues about 911 audio, and we'll correct that. And we can green sheet the unindicted case so that we can deal with all 5.
107's already been assigned to me.
Yes.
Okay. All right. So I just want to make sure they're all trending in your direction, and it sounds like it. And you also know, to make your life more complicated, there are 2 prosecutors you're working with on this. I don't know the severity of the case that you've got. Does Mr. Burns's case still seem to be the elephant in the room, and the others aren't unimportant, but it's really sorting out Mr. Burns' case that we're all focused on, and the rest more or less would fall in line?
That's accurate.
Okay. All right.
Can I add one more
Wrinkle or fact?
fact?
I like those.
There is a pending motion to suppress evidence that I filed a few weeks ago. It is a search warrant issue. I don't know if it'll need testimony, it may. But I did file a motion.
So that would be how many months late?
Late.
Okay.
But I can tell you that it was in part due to the fact that I was waiting on an affidavit in support of one of the search warrants, and the district attorney's office only produced that search warrant very recently.
Okay. So you weren't in a position to necessarily perfect the motion. You see the affidavit, you say, you know what, you believe there could be an issue with the affidavit. Couldn't know there was an issue till you got it. Now I see it. Now, they're actually, boy, it was filed 2 days after Christmas, so it is very fresh. There are actually 2 listed. Is it just a double filing, or are there 2 different motions to suppress?
It's one motion, but I broke it up into two because at the time I filed the first motion, it was, I think, just a general preliminary motion. The second motion was particularized, but at that point in time, I still hadn't received the affidavit in support of the search warrant. So grounds for the suppression are different now than they were when I filed that second motion to suppress evidence. Now that I've received the affidavit, I should probably re-particularize it because now I've received evidence.
So the motions that were filed on the 27th, they won't tell me all the issues because since December 27th, so in the past week, you've received the affidavit?
That's correct.
Oh, okay. All right. So you're letting me know that in case negotiations fall apart or you are uncomfortable or unwilling, either one's all right, to resolve Mr. James's case until you get a ruling on your still not particularized motion to suppress.
I'm willing to engage in negotiations,
Okay.
notwithstanding the pending motion.
It sounds like if it's a four corners challenge, it is something we could hear without evidence and resolve if negotiations fall apart and we're going forward with the case you have of Mr. James's. It's the kind of thing we could handle just before trial. Do you agree with that? Or
I do. I have to look again, now that I've received the affidavit, there might be one issue, a fact issue that needs to be fleshed out, but I think that would be done relatively quickly.
okay. All right. Well, let's do this. I'm going to assume that you'll be ready to try Mr. James, defend Mr. James, and Mr. Jordan, you'll be prepared to prosecute the case ending in 791 on the 23rd.
Yes.
It also could go on the 30th. I reserve the right to have a different case go on the 23rd, but that would only be for a weird scheduling issue or someone who's been in jail longer than Mr. James, because he's been in jail for a long time. So please press forward with the four-way negotiations. And what I'll be doing is having Ms. Nelson bugging the four of you saying, all right, now it's the 17th, now it's the 18th. Where are we? Just getting updates on it. Because it sounds like primarily it's a Jordan Byrne conversation, but certainly Ms. Roberts needs to be in the loop because she represents four other cases. Would you like Mr. James brought out so we can let him know what's happening, or do you want to chant? Is Mr. James up? I know he's here. I just wasn't sure if he's up. Okay, that's right, because you came out of lockup. Do you want to talk to him again, or are we good for now? Okay, then we'll keep him up. And if they can support you going back while we're calling the calendar, go for it. Otherwise, once we're done calling the calendar, have a quick chat, a long chat, whatever you need with Mr. James. And then Ms. Roberts will just keep you in that same email loop about what's going on. And please flag for me and Ms. Nelson if you run into an issue akin to Mr. Burns of, hey, I think we're going to work this out. But if we don't, and we're going to be trying one of mine, there's this issue we'd need to litigate. But my guess is that if there's a trial, it'll be the one that appears to involve a shooting. So.
And Your Honor, I don't foresee this happening, but in the event that any of mine go out, I would like to reserve the right to file motions as well. I don't, even though I've had the cases since November, but I haven't received all of the study for everything, so I don't.
That's not, you have come on very, very late. I poked at Mr. Byrne only a little bit because he's been on for a while, and then why are we getting this motion to suppress only now? But he's explained why. He was in a little bit operating in the dark. He had a warrant with none of the supporting materials. And so he needed to file a placeholder, and now he thinks there is a potential area of concern, but that's now negotiating leverage for him. So by all means, if there's things we'd need to work through, we'd do that. Okay?
Maybe we can all talk at the end of the calendar.
That would be great. I encourage that since you're all here. So take a seat. We'll make sure, Ms. Roberts, that you can see Mr. James.
I'll see you.
All right.
Thank you.
He'll feel like he's getting a lot of attention.
So, do you want to go right now?
If you guys can support that, that'd be great. Thank you. All right. Position 8 is Mr. Thompson. Mr. Thompson, are you here? Good morning, sir. Mr. Jordan, your case?
I'm sorry, Judge.
Position 8? Not your case?
Yes, this is my case, Your Honor.
Okay. You seemed perplexed by it.
I already, since Mr. Johnson isn't here, I think this case already went out of mind.
Okay. And I'm not going to put you on the spot in any way other than I wanted to make sure it was yours. If it was in a special unit, I needed to be able to track it that way. Mr. Thompson, you heard what I had to say about Mr. Johnson, your lawyer, how he is in, I don't know, maybe you came in late, but he is in trial right now, the big Young Thug trial. And that means he is not available for a while. Less of a problem for you because you're on bond, more of a problem for the folks who are in custody. But I can't make Mr. Johnson be in two places at once. And so you're a co-defendant of Mr. Norris in one of Mr. Norris's cases. Mr. Norris will likely have a trial on one of these weeks. But it won't be your case. I think, Mr. Abate, it would be the murder that will go out first, not Mr. Abate.
We're still in here for the state, and we're ready on the murder. I know Mr. Toll's emailed the court. He's also ready for the week of the 30th, so we'll be ready to go.
Great. Can you give me your last name again?
It's Olivier, O-L-L-I-V, as in Victor, I-E-R-R-E.
Olivier. Nice to meet you, Ms. Olivier. So you'll be handling Mr. Norris's murder case if it goes the week of the 30th. And I saw what you saw, which was Mr. Toll saying, I've got leave next week and today, but I'll be ready to go on the 30th.
Yes, Judge, and I'll also be handling the Tolbert case as well.
Well, Mr. Abate's just handing out presents left and right. All right. So 30th. Does the 23rd work for you for the Norris case?
It does not, Judge. I'll be in Orca the week of the 23rd.
Meaning,
We have a trial calendar at Orca, and something might be going out the week of the 23rd.
and whatever goes out, you're covering?
Correct.
Okay. I have a special spot behind everyone with Judge Emerson. So on the 20th, so it may be we reconnect and it may be it's one of these cases. But we'll see, because in talking with Orca, I'm learning that a lot of those cases are going away. But now I know how to keep in touch with you. So I'll do that. I may become like Orca sub for the week of the 23rd, but it would be Judge Emerson and we'd do it in here. So same place, just different judge.
I understand.
Okay. And so folks are clear, we wouldn't be trying 2 criminal cases the week of the 23rd. We'd be trying one. If we're using Judge Emerson, I go try a civil case in a different courtroom.
Okay.
All right. But we're leaving Mr. Thompson hanging there. Mr. Thompson, do you have any questions procedurally? You were here today, which is what you needed to do. You got something in the mail telling you to be here. Have you and Mr. Johnson ever met, really? Okay. All right. Mr. Jordan, does Mr. Thompson's case fall into a category of if we had a lawyer in place for you to talk to, something might happen? Or I know it's complicated by the fact that you've got Mr. Norris attached to it, and his fate may be determined by Ms. Olivier's prosecution.
Your Honor, in regards to that, nothing in the notes that I have seen have indicated any communication between Mr. Johnson and the previous ADA about it being dispositive for Mr. Norris as opposed to Mr. Thompson. So at least I don't have that knowledge right now, Your Honor.
Okay, well, I know you're going to focus on other things. You may want to make a note as to what the state would do if Mr. Norris is out of the picture. If his 3 cases resolved by way of a conviction in the murder case, then you'd be just dealing with Mr. Thompson, and that may change how you'd be thinking about it. Mr. Thompson, you are free to go. I appreciate you being here. We'll send you another notice when we get Mr. Johnson back in pocket and can try to move forward with your case, okay? All right, thanks for being here. That gets us to Mr. Norris. We did not bring him upstairs because Mr. Tolles wasn't going to be here. And you've got two of his cases, Mr. Jordan, but if we go forward, your colleague, actually it was Mr. Abate said that's which one will go first, but Ms. Olivier will handle it. And that would be the week of the 30th.
Yes, sir.
Okay, all right. That gets us to Williams and Tolbert. Ms. Feely, we had specially set this for the week of the 30th. All right, is that something that you can still do?
So there has not been a motion to sever. I was planning to be ready for that case to go on the 30th.
Right.
But with the Johnson issue, I'm not sure.
Okay. Ms. Olivia, what's the state's view on severance? Is the state's preference? I know I've talked with your colleague who's sitting right next to you, but my recollection is there is not a Bruton issue. There's no reason why the state felt that severance was legally required. And I don't remember the state ever saying, actually, we want to sever because we could at least move forward with one guy. Mr. Williams has had a change of attorneys a couple times, but it's been more ready more recently than Mr. Tolbert.
At this time, Judge, we anticipate trying to close together.
Okay. So Ms. Feely, Mr. Williams is downstairs, I think. I think we flipped it around. We brought Tolbert up and not Williams, because they're supposed to stay separate. Do you want to talk to him today?
I'll go by the jail.
Okay, all right. I don't think it makes sense I don't intend to sever. And I'm not hearing you say you're filing a motion to sever. So I'm going to leave the special setting in place just to see how the next few days go with YSL. And then I promise I'll let everyone know when I'm declaring Williams and Tolbert a no try, but they've been in jail longer than other than maybe Ms. Boyd, all these other folks, and it needs to happen. All right.
There's a pending Jackson Dale motion on Mr. Tolbert.
Yes.
After this, obviously, if you listen to it, that you would create a group if you were to use it. The intent was not to use it was to make sure that Your Honor found that it was knowing, voluntary, and safe to make, so we use it if he was to justify that, use it across.
Yeah, no, and thank you for reminding me, but I've got it. I haven't tested the new one yet. But Mr. Cladis, previous lawyer for Mr. Tolbert, I'm not sure if I'm challenging it. And your point was, it doesn't matter whether he's challenged. The state needs a finding that should the state want to use it, that's a usable statement. Okay, I'll make sure that happens before the trial. All right, that gets us to Mr. Conley, Raheem Conley.
Judge, he's in custody.
Oh, okay.
This is one of the issues where Mr. Johnson has one of his cases and then I have the other.
Oh, yeah, look at that. But you've got one that may well be work outable, but why work it out given the other one?
Correct, Judge. I do want to speak to Mr. Conley, though. He's very upset about the whole issue with the YSL trial. Mr. Johnson's tied up in and being able to speak to Mr. Johnson. So I do want to talk to Mr. Jordan as well to see if he can work out my case.
Okay, and I don't know how it would work. Does Mr. Johnson represent Mr. Conley privately or because it's a conflict case?
It's a conflict case on that one.
That's complicated then, because I'm already getting warm fuzzies from GPDC about having a stand-in person meet with a client of Mr. Johnson's for purposes of plea only, not I'll now try the case. But that wouldn't be you anyway, because there's a conflict, although, I mean, I don't get in the middle of those things. Mr. Conley could certainly waive it. I don't know that whoever was the source of the conflict would waive it. I don't know why there was a conflict, et cetera. But it's frustrating that there's a competent lawyer talking to Mr. Conley who's like, hey, I just wrap it all up. I don't know that the state's interested in wrapping it all up, but let's be thoughtful and creative about ways we might be able to sort everything out for Mr. Conley. Even if it's a quick shuttle diplomacy with Mr. Johnson, where we bend his ear for 5 minutes and he says, oh, yeah, I think that's great. Given what you're saying, Mr. Conley's mood is.
Yes, Judge, and Mr. Jordan and I have spoken about what we were speaking about, Judge, so if I could just speak to Mr. Conley and come back to this one.
Okay.
I appreciate that.
Is Mr. Conley upstairs? He's up. Great. All right. So he was out on bond on the older case and then picked up this new one? Or is the new one something that happened in the jail?
Well, my case is actually older than the
Okay.
other case.
All right.
Just that I had it later.
All right. Ms. Boyd is next, and her older case is on the trial calendar. We also have a plea and arraignment calendar to arraign Ms. Boyd. But we can't. Do you have any sense, Mr. Hiles, and Happy New Year, as to why it's a conflict offender case? Was there a co-defendant? Is it the victim or?
Yes, Your Honor, the co-defendant was Jaleesa Lowe.
Okay.
She took a plea about 2 years ago.
And she was sort of an accessory.
She was charged with financial credit card theft and fraud, one of the, some of the proceeds from the home invasion.
Okay.
And
And for whatever reason, the PD's office was on the defendant who had financial transaction card fraud and not the murder.
back then, they got first bite at the apple.
Okay. All right. It's not how it's supposed to work. Okay. So I don't, Ms. Boyd, we didn't even bring upstairs because we can't arraign her or waive the arraignment or anything like that. And I don't think this is one where it makes sense to ask the Metro Alternative Defender to find a substitute for Mr. Johnson unless that person's going to own the case.
Yeah, they would have to own it. I know she's my oldest incarcerated case.
Yep.
We're ready, but I told everyone to stand by because I knew this was coming.
Yeah, we can't, I mean, there's other than Mr. Johnson freeing up, but if he frees up, I'm going with especially set. They've actually been in longer, Tolbert and Williams. Not much, but longer is longer. So I'm just saying, if the only, even if we got Mr. Johnson back for the tail end of the calendar, it would be Tolbert and Williams, and then we'll just keep putting Ms. Boyd up at the top.
He asked to sit down with me, and we'd made a date to do that. And then that was the day we met. It was like the first day that Judge Glanville really started hammering all the motions.
Yep.
Him and I have not been able to sit down. I don't think it.
Oh, he had to postpone or cancel that meeting?
Yes.
Okay.
I mean, it's been what, 3 weeks now?
Yep.
Since they've started.
Yep.
And I don't think it will change the case. They come to me asking for a number that I did object.
Oh, in the Boyd matter?
Yes.
Yeah, okay, yeah, because your predecessor on this one called it sort of the case in a box that tries itself, and Ms. Boyd needs to work it out. You've made it more complicated with all these new charges, but, okay.
I don't think it was quite as straightforward and as simple as kids in the box, but I just, based on the facts, it's trial.
Okay. All right, hold on 1 second. Let me get an update from Mr. Byrne and Ms. Roberts. So you met with Mr. James. Are you gonna now meet with the prosecutors?
Yes, as soon as possible. Ms. Roberts has an appearance at 10 o'clock with Judge Cox, so.
Okay, we'll let Judge Cox know that she may be a couple minutes late, but I'll get through the calendar and then you guys can confer. Great, thank you. All right, thank you, Mr. Hiles. Derek Avery. Mr. Avery is here.
Speak with Mr. Avery and then I can update my announcement.
All right. Mr. Avery, when I'm done calling the calendar, you're going to meet with Ms. Feely and we're going to figure out, is Mr. Avery, we had 2 cases from our last calendar where one person got stabbed and we weren't able to work it out because we couldn't get him back in. And then there was the guy with the heart condition or something. That's Mr. Avery's not one of those. Okay, good. Glad to hear that. All right. Did you have a question for me?
Yeah, I Adams.
That's what I was
That's my
thinking.
lawyer.
Okay.
Yes, that we hope this report.
Well, he's got to be here because he represents a guy that we may be trying during this calendar. We'll see. But he'll need to be here. So Ms. Feely's still going to talk to you real briefly, and it may be that you guys say farewell to each other. Then we'll need Mr. Adams, and you'll need to be here till he gets here, okay? All right. Jason Bright, I owe both sides are ruling on the immunity motion. If the motion is denied, Ms. Feely, are you ready to go forward? And you have a preference of weeks?
I do not on that one, and I don't think it would take as long either.
All right. Ms. Olivier, you're doing this one too?
Yes, Judge, and it would be a soft ready ideally the week of the 30th if it had to go to trial.
Okay. Had to go to trial as in you and Ms. Feely may be talking. Obviously, if I grant the immunity motion, it doesn't have to go to trial. It goes up on appeal. But what's the soft ready / if it goes to trial?
So Judge, I reached out to Ms. Feely when I initially looked at the case and we haven't spoken on it. If I would like an opportunity to do that.
Okay. I owe everyone a ruling. I'll get on that. And then I guess that will inform negotiations. All right. But Ms. Feely, you're ready any of the weeks. You're asking for the 30th. Do you need to speak with Mr. Bright? Okay. Brandon Way, that's Mr. Adams's case, and we hope he makes it here. Mr. Abate, you keeping that one?
Yes, Olivia will be covering that as well, excuse me. But the ballistics are still pending in the GBI, so I'm having my investigator actually go pick them up because it's taking entirely too long. We have a contract with a private lab now, so they can get them done much quicker. At the expense of unfortunately taxpayers of Fulton County, but we would suspect we request the 30th if this thing's going to be on trial.
Would that give you realistically enough time for the private agency to do the ballistics?
It would be very close, so I would be a soft yes, but likely a no.
Okay, so several soft readies here. Maybe the taxpayer money can get it ultra expedited. We'll need to hear from Mr. Adams. He may say, I got no problem with that. Mr. Way's been in jail for a long time, so he may say, let's do it the 30th. Okay, all right, we'll hold for Mr. Adams. Mr. Abate, the ballistics in this case, is it your sense that they are dispositive, critical, central, or you just want to be thorough so that someone can't say, how do you know it wasn't a 9mm as opposed to 30 caliber?
This is, I would say, they're pretty critical because there were 3 people who were shot. This is going to be either he wasn't there or there were multiple shooters. So I think it would be important to have these problems as the central issue to part of the case.
Okay, thank you. And you said, Ms. Nelson, Mr. Adams is telling us he's on his way.
Yes, he said estimated about 11.
Okay.
He said, I could believe when it.
Okay. Position 20 is Mr. Jenkins.
Judge, he's not here. He is in Clayton County Jail.
Oh, it says that. Yep. Okay.
He has.
If he were here,
Judge, we are missing some surveillance footage that could be dispositive of the case. I know Mr. Jordan's trying to get it. My office, we also subpoenaed it. Neither of us have been able to get it. So I did just want to put that on the radar.
is it who owns the surveillance footage?
So it's unclear from the police report. It's in the report, it says that they have this footage. So that's why subpoena went out to College Park PD. They don't list specifically which business, so I don't know if Mr. Jordan has more information about that. But there's multiple shooters according to the report and the witnesses, and so that's how Mr. Jenkins gets charged, is because of this mystery surveillance footage.
Okay. And so that hence its dispositive nature. If it shows someone who's not Mr. Jenkins, then weaker case. Okay. But your review of the College Park police report makes it sound like College Park police obtain, they didn't just watch, because sometimes we get those cases, like I looked over the shoulder of the vendor and I saw the footage and I made these notes, but I didn't take the footage.
And Judge, I can confirm it's not on any of the body cameras that we received.
Okay, all right. What do you have to add, Mr. Jordan?
That is correct, Your Honor. The state doesn't have much to add. This case is, of course, going through the hands of multiple ADAs. It seems like we've all tried to get that surveillance footage from College Park. I requested it on December 14th. They said it would be ready by the 20th. Then they asked for a 10-day extension. I followed up with them again and haven't heard anything back. The only additional point that the state would have to add is that the family of the victim does believe that there will be other family members that may testify to seeing the defendant, Mr. Jenkins, shoot into the crowd, which is what the case is about. So the state, in the mindset of having a quick judicial process here, the state will be ready for the 30th. If Your Honor was inclined to put it on another calendar. At that point, if we don't have the video, we would just move forward with the witness testimony.
Mr. Jenkins is in Clayton County. Why?
But he's been in Clayton County since January 7th of last year. He's got at least 2 cases there, potentially 3. One of them is a little more serious than this one.
Okay. He's listed here as having a bond. I think the name is ringing a bell. Let me just look it up. What I don't want to have happen is he disappears because he gets out of Clayton.
I think he may have revoked his bond last time.
That's my recollection. Once you told me, hey, he has something a little more serious in Clayton, I think I revoked his bond. Yeah, a long time ago in March. So we've been trying. You still don't have the surveillance video?
It's been at least 3 or 4 ADAs and they've all tried. It's not from a lack of trying from the state's perspective, Your Honor.
Okay. So it sounds like, Ms. Wood, your preference would be, we need to get this because it could be real good for Mr. Jenkins, and he's not going anywhere anyway, so why not wait on it?
Yes, Judge.
Okay. Can we subpoena can you subpoena someone from the College Park Police Department to be here on whatever this Monday, the 9th?
Yes, sir.
And to be here with the surveillance footage. So someone will show up and I will talk with that person as to why they don't have it.
Yes, Your Honor.
Thank you.
He's on the 23rd calendar. Do you want to produce for that 23rd?
Please. So we'll produce Mr. Jenkins for the week of the 23rd. As in, we'll make sure he's in Fulton County. But I would like the College Park custodian, lead detective, whoever it is, subpoenaed to be here in court 9 a.m. on Monday, the 9th.
Yes, Your Honor.
And you should be here too, even if one of your cases isn't rolling out.
I will be here.
Okay.
Thank you, Judge.
All right, Mr. Dill, position 21.
Dill is in custody. His mother is usually here, but this is one I need to get with Miss Olivier about, I can't remember if this is.
Mr. Whitenauer.
Mr. Whitenauer, okay. If this is the one that I have videoed that I haven't been able to play, or if I have the video, so I will confirm with him. Mr. Dill is sitting on a sentence. So this has been one that's kind of gotten slow to get started because he was in the OC. And so I've only met with him a couple of times since he's been back since November, but I would need to get an order to bring the laptop in and show him that video and stuff.
He is still under sentence and we're borrowing him from DOC, or he finished his sentence and he's back?
He has a max out date of March 3rd, 2024. Okay,
so shorter sentence. All right. And the video is pretty important to the case, or this is the guy no longer living on the ground? It's the former. Okay. Let's say we made that happen real soon. And if he's here today, could we do it today?
Yeah.
Judge, I do have the video and the software to play it. I just need to run back to my office, get my actual hard drive, and I can queue that up for defense, client. It is color 4K surveillance video from the parking lot that shows safety position, the defendant creeping through the parking lot, hiding behind cars as the victim pulls up, exits the car. The defendant falls down the sidewalk, assaults him, and then shoots him with a gun. There's also a witness in this case to that murder, Judge. Her name is Tatiana Willis. She had a heart valve replacement in 2021. She's now pregnant and has a due date at the end of February. Because of that heart valve replacement, she's indicated to me that she is considered a high-risk pregnancy and has indicated that she does not want to risk a miscarriage or an early delivery by having to come in for trial, and has indicated that she would then be taking maternity leave for about 6 weeks, so that we would be asking that if this were a trial, that it'd be in April, Judge.
Okay. I don't want to jeopardize her situation in any way. What is it about? Is she bedridden right now until she gives birth, or it's the stress of coming into court, or what is it about sitting in a chair for a couple hours, if that would be problematic?
I think from what she's told me, it's that because of her heart condition, that could have a negative impact, that stress could have a negative impact on the fetus.
Okay.
I don't have any doctor's notes.
No, and we'll work through that if we need to. I'm not interested in taking any risks for her or her soon-to-be child. But we have to balance competing interests. Did she articulate at all why the maternity leave isn't something that for 2 hours could be interrupted, because then the child is on the outside and not on the inside?
Right, Judge. I think that was more of, I was just sharing that with the court. That's what she shared with me. I would agree with you that once the baby is safely and healthily delivered, that those concerns maybe aren't as central.
Okay. Why is this your case?
This was a DV matter, Judge. It's kind of I guess, described as a love triangle.
And the woman who is pregnant is part of she's one vertex of the triangle?
Yes, Judge.
Okay, so it's not just I don't know anyone, but I did see this guy in a green hoodie walking down the street. I
was coming to see her, and so she was a foot away at the time of the shooting and murder.
Okay, she'd have lots she'd need to talk about.
Yes.
Okay, understood. Ms. Feely, any thoughts about that?
That sounds reasonable.
Okay, I mean, you're not objecting. If the way we handle Mr. Dill's case is one, since we've got everyone here, let's watch that video today. But two, we may not prioritize this one. It's a newer case, and my numbers show Mr. Dill hasn't been in custody all that long. 3 years less than Mr. Williams. And so I don't want this to drag out, but that may give you more time to be with Mr. Dill and address the understandable medical concerns of, what was the last name?
Willis.
Ms. Willis. Okay. All right. So this to me would be one of the more soft readies than some of the things I've heard.
Yes,
Okay.
I'll be the third soft ready, Judge.
Okay.
We will train Mr. Dill for his employee.
Yeah, I think everyone's ready to trade you, Mr. Abate, with that voice. I don't know. Number 22 is Ms. Smith, LaShondra Smith. Hey, Ms. Smith, how are you?
I'm doing well.
It's good to see you.
Same here, Happy New Year.
Happy New Year to you. You're one of Mr. Johnson's clients, so you may be in this seemingly endless cycle. I promise it's not endless. Mr. Johnson is just real popular. Mr. Jordan, is this one of the cases where if we were able to get a colleague of Mr. Johnson's to spend some time with Ms. Smith, that might be productive?
I believe so.
Okay. You're ready, but it's really one where you'd prefer to negotiate something with Ms. Smith and her lawyer.
Absolutely.
Okay. Ms. Smith, as long as you don't object, I'm going to see if we can get a colleague of Mr. Johnson's to spend some time with you, not today, but we've got a month to work with here to spend some time with you as well as Mr. Jordan to see if there's a way to work this case out. Are you all right with that?
Yes, I am.
Okay. I'm not promising I can make that happen, but I did get some positive noise from the team of lawyers who work with Mr. Johnson that they might be able to get one of his partners to spend time with you on that. All right, Ms. Smith, anything else? All right, you are free to go, but don't be surprised if you get contact from someone who says, hey, I'm lawyer so-and-so, I work with Mr. Johnson. Don't think it's a trick or anything like that. That'll be the good news, that we're able to line someone up to see if we can sort this out.
Right.
All right, Mr. Jordan, anything before Ms. Smith goes?
No, Your Honor.
Okay, thanks. Sam Greer.
Morning, Your Honor.
Hey,
This is one that if we can have someone sign from Metro, we should be able to resolve very quickly.
Mr. Greer's in custody?
Mr. Greer is in custody.
Okay. They told me they were going to prioritize that scenario over Ms. Smith's if they end up saying, look, we could maybe only 2 or 3 folks. So any sense, oh, it's a big number too. He's been in custody for a while. Okay. Michael Jones.
That is mine. She's present. I have some information for Mr. Whitenauer, and then I can update the announcement.
Okay, so Ms. Jones, did I say your first name correctly? Okay, Ms. Jones, I need you to continue to sit tight. Although, Ms. Charles, you're standing up. All right. Your lawyer's going to talk with you some. They're going to talk with Ms. Charles, who's the prosecutor, and then we'll figure out what we're going to do next with your case, okay? Thanks. Sadiq Parker.
She's mine. I do need to meet with Ms. Charles as well, and then I hope to have an announcement or perhaps a plea.
All right, Mr. Parker, just like Ms. Jones, your lawyer's going to meet with you, talk with busy Ms. Charles, and then we'll figure out what we're going to do. Trial on one of those weeks, or maybe we're working the case out, okay? All right, thanks. Nicholas Horton.
Judge, I've been trying to make contact with Mr. Horton. I think he did today, because I have a new offer. So I'll come back to this one.
Any reason why you would think he wouldn't be here?
I have not spoken to him this week, Judge, but I have had pretty recent contact with him, so.
All right, well, why don't you check? Because if he's not here by sort of lunchish, then bench warrant for Mr. Horton, which we can always lift if he walks in later today, but today's the day.
Thank you, Judge.
Yep. Cortez Gibson. He and his lawyer often aren't here.
Let me see if I have a recent.
Bench warrant?
Yes, Your Honor, the state will request a bench warrant.
Okay. Monte Wadley. Hey, Mr. Shepherd.
Dennis Shepherd, I'm appearing on behalf of Jeannie, Kim, and myself. Mr. Wadley is present in the courtroom. We have filed a motion for continuance for, there's a number of reasons. The main reason is we're also missing surveillance video. But to get to the point of this case was just indicted in, I think, April or May of last year. It's a 22 case. And we got an overwhelming amount of discovery, including about 50 videos from the state. And we've been going through them, but it's a lot. It's a lot. This is a rape case, so the stakes are very high. We've had some preliminary conversations with the state's attorney about some type of a plea offer, but we really haven't got a firm, this is what we'll do from the state yet. So we've never had a final plea. We've never had an ability to enter a plea to whatever.
So we don't do final pleas anymore. It's the status conference, which is like final plea. And there was a status conference in Mr. Wadley's case. So
it got continued. We never actually showed up for that.
Why did you not show up?
Because it got continued.
Okay.
This is the first time I've been in court on this case.
Would Miss Kim have been in court? No?
Without me. But whatever it was, it got taken off that calendar.
Okay. Yeah, and September 13th was the status conference calendar, and then the result was further notice to trial. So I don't remember what happened. I'm not
Okay.
doubting your recollection, other than that the way I processed whatever happened on the 13th was to say further notice to trial. There's a motion for continuance, which you're articulating now. There's also a motion to compel discovery. Is that the surveillance?
Yes. And just, we would like the opportunity to speak with the state's attorney about a plea. This is a case where the two meet at a car dealership where my client is buying a very, very expensive car, and she works at the car dealership. They start talking. Next thing you know, they make plans. He meets her in Henry County. Their plan is to go to the 12 hotel, get a hotel room, spend the night. So they go to the 12 hotel, and there's surveillance video of them coming into the hotel. And then they check into the room and they go upstairs, and then sex occurs upstairs. And then after the sex occurs, the stories change. At this point, the state's version is that at some point while they're in the room, she declines to have consensual sex. Our side is that they have consensual sex, and after the consensual sex is over, she regrets having sex, goes downstairs, and reports that she had been raped.
What's the surveillance you don't have?
The surveillance is one, them going into the hotel
Mhm.
and checking in at the counter, all fun and playful.
Okay.
Two, there's an unguarded moment when she comes downstairs and walks through the hotel lobby. She's captured on the surveillance video, and we have spoken with the hotel manager. And according to the hotel manager, the police obtained a copy of the video, surveillance video, and also obtained the bedding from the room. He also reviewed the video, and it did not appear that the girl was upset, but calm and normal. So according to the hotel manager, they have also had an insurance investigation into the matter because they are fearful of being sued by the victim. So that video captures her in an unguarded moment.
You know about it because it's been written about. You don't know about it because you've seen it.
He won't give it to us.
He, the hotel manager.
Yeah.
He's got it still.
He had it
Okay.
a few months ago, but we thought it was in the discovery. So we go through all this video and it's not there. So according to the hotel manager, the police got it. And then it was never turned over to us. Now, hotels will give surveillance video to police, but you've never been a defense attorney. So you don't know that when you're a defense attorney and you ask for something like that, you don't get it.
Okay.
So we've tried to get it, but we can't.
Let's hear from Ms. Charles. Ms. Charles, what do you know about surveillance footage from the 12 hotel?
Your Honor, yes, it was the first time I learned about the possibility of the existence of this video. All of the videos are all discovered that's currently in the state's possession, which Mr. Shepherd is rather 50 of them, were shared in May of this year. I have been speaking with Ms. Kim before the holidays about potentially, resolving the case. Of course, they have a very different version of the facts. Our victim has a version of the facts. We have out-court witnesses who corroborate her, in our estimation, her version of the facts. So we remain even after the holidays. When I talked to Ms. Kim yesterday, still in the trial posture. Nothing in the reports, in the CSI reports, in the subsequent supplemental reports, indicates an officer ever retrieved a video. This is something that Ms. Kim indicated when they did their investigations in preparation for this case. They were told that by one of the guards or manager downstairs in front desk, they think officers may have gotten the video. So when she told that to me yesterday, I reached out to the detective to confirm the same. I haven't yet used confirmation call back from him, so I intend to follow up. But all of the body cam, which captures the victim as she sat in the back of the reception area waiting for the police to come, all of that's been shows her demeanor. Mr. Shepherd's position is that video would show her coming down from the room and going down to the front desk, ask them to call 911.
I mean, the video is going to show what it shows. You don't have it.
I don't have it.
You don't know yet if APD has it, but you just asked once Ms. Kim flagged it for you.
Because all of the other evidence, the bedding and all of that, we do have in our possession. CSI reports, all of that was turned over.
Mr. Shepherd, you were reading from what sounded like a report, but maybe it was your notes where the hotel manager says, I gave a copy to the police.
He doesn't say he thinks he gave. He says they got the video and the bedding.
Okay, and that's the hotel manager telling you it's not a report from the insurance investigation.
Report from one of my employees.
Okay.
So it's an employee of my office.
Yep.
In Judy's office that wrote this and met and
the hotel manager said they got, meaning the police got bedding and surveillance footage.
And if you think about any police report you've read lately, if there's a rape at a hotel and there are cameras everywhere, the thought that the police would not get the surveillance video is nonsensical.
But it somehow, it doesn't say in the police reports that we got the surveillance video, or that's what you'd be reading to me is the police report.
Not in the police.
Okay, which doesn't mean they don't have it. And Ms. Charles is checking. I'm happy to assist. If you want to get to me a proposed order that would direct the hotel to get to you or Ms. Kim or your employee, all footage they have you'd know the date and time and all that kind of stuff. I'm happy to assist. I think, given that the videos were handed over in May, that we ought to keep this on the trial calendar, not for next week, but the week of the 23rd. That will keep folks focused on it. I am heartened to know that Mr. Wadley has two lawyers. So I know you're busy and Ms. Kim, but that's sort of twice the horsepower that could be focused on it. And as I said, I'll assist on the hotel end of things, and Ms. Charles is pursuing it with the lead detective. If the lead detective said, oh, yeah, we've got that, that needs to be produced right away. If something that is late disclosed causes you to say, no, we can't go forward because of that, let's talk again about a continuance.
The other thing is we have not received a witness list from the state. We have a number of people who we're going to have to subpoena because if the state is not going to call these hotel employees who is going to provide testimony that counters their viewpoint, then we need that also. We also want our client to be able to get a psychosexual exam.
So you're welcome to do that again.
Can't get all that done by the 23rd.
Okay, but
I'm announcing not ready.
Okay. I'll look for an order from you if you want help getting things from the hotel. And Ms. Charles, any reason you couldn't get to Ms. Kim and Mr. Shepherd a tentative witness list by early next week? Okay, please do that.
Once again, the 23rd is how many days away?
Well, if we don't do the 23rd, we've always got the 30th. So there's time in there, but I'm going to repeat, and I've heard you say not ready, and we'll see what happens as we get closer to the 23rd or the 30th. This was a case where your client was arraigned back in May. So it's been a bunch of months. I hear you that there's some moving parts, but this trial calendar was published a while ago and the motion for continuance wasn't filed until yesterday. Right now, I'm going to keep the pressure on. That may also prompt the kind of conversations you were hoping, Mr. Shepherd, that you or Ms. Kim would be able to have with Ms. Charles. So you'll get a witness list by early next week. If you don't, let me and Ms. Nelson know that. And I'm happy to get a proposed order from you that would dislodge from the hotel the surveillance footage, but it may be moot if we learn from the lead detective, hey, here's that stuff. Okay.
I understand. Thank you.
Thank you.
I'll be excused.
Do you need to, if you don't need to talk with Ms. Charles? Okay. Mr. Wadley, you are free to go when Mr. Shepherd says you're free to go. He may want to talk with the prosecutor for a sec and then talk with you. All right. Gerard Hanna. He's in custody. No, he's not in custody. You Mr. Hanna? All right. When'd you get out?
2 days ago.
Well, all right. How are things going?
Going good.
All right. Look up your case. What do we know from Mr. Jones?
Judge, I've communicated with Mr. Jones by email. I received a voicemail from him yesterday. He's indicated to me in response to my plea offer that this would resolve as a plea. He indicated in his voicemail that he had gone to the jail hoping to speak with Mr. Hannah, but learned that he had been released and was not able to speak with him thereafter.
Okay. So, Mr. Hannah, I'm gonna ask you to sit tight. We're gonna figure out why Mr. Jones isn't here and if he can be here this morning, so that you can talk with him. He can talk with you because I think he's got new news for you about a possible resolution. And we'll see what we can do. If it's not working out, when could you be ready?
I can be ready whenever the court wants to call a case.
Monday? I just don't have a lot going out on Monday now, thanks to
Sure.
YSL.
Right. May I just have a moment, Judge?
Yes, it's the last one on this calendar, so you can have a moment. We do have the calendar for the 23rd. I'll call that in a little bit. There are folks who need to talk with each other and places they need to be. So why don't you all confer? A number of the cases on the 23rd we've already talked about. So why don't you all confer? Was there anything I needed to do right away or just be available? I'll just be available. All right, keep me posted, please. Oh, everything on the 23rd is from this calendar. That's good. Okay, so we've talked about them all.
The jury room's still open?
It is. Use it. If it's locked, let me know and I'll get a key.
All right. Judge, I just have a quick question for jury.
Okay.
It's that phone order and such. Who's that on?
That is for Bria Walker.
Oh,
We have, Ed's.
yes, good, I'm glad you did.
Okay.
Throwing emails, okay, great.
She's gonna be, we're gonna be meeting this afternoon, so
Okay.
do I need to let her know? She might need to.
Well, no, if you let me know that you guys. I didn't hold on to it. Yeah.
Great. Great.
Otherwise, yes.
Thank you, ma'am.
Mhm.
Judge, can I be excused?
Yes, sir.
Thank you.
Were you, I didn't write down who all the lawyers are. So we'll circle back if we are able to find a partner for Mr. Johnson on Greer, but it wasn't your case where someone could come watch? No, that was Dill. That's not yours. Okay. Right.
And Judge, you might also let them know, just like say, that's one that we can get done that day. You just need someone.
Okay. Yep.
Thank you, Judge.
I'm reaching out to Mr. Jones.
Great. Thank you. Let me go back.
Was moved from the status from the schedule.
He didn't say. He just said the status conference, it got continued and he never had a status conference. I'm looking only at Odyssey, and on the 13th of September, there was a status conference and it says result, further notice to trial. That says.
I know it's in my notes, says Judy Kim.
That was my understanding. I remember, I think it was virtual. I think because he's on bond, I think Ms. Kim appeared on a screen. So,
It was a Tuesday, so we were here. So
yeah.
Mr. Dill's office. And check her.
I'll just talk whenever you're done. I'm not here, I'm talking. Okay.
Oh, he gets to go into the back.
Yeah.
Okay.
So I didn't know, I didn't need anything. Yeah, so now I'm in. Thanks.
I'll talk to you.
All right.
McBurney, would you be able to speak to Mr. Conley right now about the situation that we have with these cases?
Sure.
He's eager to speak to the court.
Okay. Hey,
Hey, I'm gonna talk to Mr. James and then I'm gonna be heading out.
okay.
Good morning, Your Honor.
Mr. Conley, how are you?
Good morning. Not so good.
Okay, why are you not so good?
I've been going through it, like with the officers, inmates, the jail.
Ready to be not there anymore?
Yeah, it's 100-degree hot out. Heat broke.
It's hot?
And the heat broke in the whole jail.
Oh, it's cold.
No, it's hot.
It's hot.
The heat stuck on in the whole jail. There's no water.
I heard no water. I heard no heat. It's actually too much heat.
Yeah, it's too much.
Too much heat. Well, you shouldn't be wearing a sweatshirt then. Let me tell you where we are procedurally. We have one prosecutor for you. That's Mr. Jordan standing behind you. But you've got two different defense attorneys. You have Ms. Wood, who has it's actually an older set of facts. It's a newer indictment. So I've been calling it your newer case, and Ms. Wood helped me understand. Actually, those allegations are older than the case that Mr. Johnson has. And Mr. Johnson is our issue. And there's nothing wrong with Mr. Johnson. Great lawyer, but he's on that YSL case. And so he is busy, potentially for the next 3 or 4 months. That's not your problem, and it shouldn't be your problem. But there was something about your case that involves an allegation of a shooting, the case that he represents, that caused the public defender's office to say, we cannot represent you. I don't know if it's the alleged victim or if there was a co-defendant, but there was some reason why Ms. Wood couldn't take what I, again, am calling the shooting case. I'm not saying you shot anyone, but that's shorthand for it. So your shooting case, Ms. Wood's office said, we can't represent you for ethical reasons. Again, maybe it's the victim, maybe it's an eyewitness, someone who would be involved with the case they had represented. So they needed to come off your case. And that's where Mr. Johnson comes in. He picks up conflict cases. No conflict with this older case. You supposedly damaged something. And so Ms. Wood is on that one. What she shared with me is that you are ready to do business on both cases. We cannot recreate Mr. Johnson. He can only be in one place at one time. I just got an email from Mr. Johnson's supervisor saying that I can reach out to his supervisor and they will get a colleague of Mr. Johnson's, not right now, but in the next few days, to meet with the prosecutor as well as the client to say, hey, can we work something like that out? So that's plan B. Plan A is you have a lawyer right next to you with whom you could choose to discuss your situation, but you would need to have a meaningful conversation with her about what that conflict was, where Ms. Wood would be able to say, here's why you might not want me, meaning Ms. Wood, to represent you. It has nothing to do with her skills. It has to do with whatever the conflict was in the shooting case. If she says, but Mr. Conley, if you don't have an issue with it, I'll represent you, and you say, I don't have an issue with it, then Ms. Wood is in a position to help you try to resolve your two cases. But I would need to get on the record, meaning Ms. Wood would need to say it on the record, and you'd need to say it on the record. Here's what the potential issue would be, and I, Mr. Conley, fully understand it, and I waive that issue. And Ms. Wood would need to say the same thing, assuming it's waivable. There's every once in a while, I'm not trying to get too complicated on you, there are issues that can't be waived by you and Ms. Wood. It may be that source of the conflict, and I'm making it up, but let's say the person you allegedly shot was someone who'd been a client of Ms. Wood's 4 different cases. That guy would maybe need to say, you know what, Ms. Wood, I don't mind if you represent Mr. Conley in this case. If it's just that the conflict is that the alleged victim at one point was represented by Ms. Wood's office, I think we can get around that, but we need to have that kind of discussion. We don't need to do that if you're okay with Plan B, which is in the next couple of days, getting one of Mr. Johnson's colleagues to come talk to you and to talk with Mr. Jordan. But I'm not in the driver's seat on this one, what you are. Have you had a chance to talk to Ms. Wood about it?
Yes, I spoke Ms. Wood about my felony criminal damage. Like, they were saying that they can get it dropped down to like disorderly conduct or something like that.
Your old case.
So I was saying, so whatever happened to the statement from the investigator when they gave me a signature bond?
We'll get into all of that
Okay.
again.
So, yeah, I don't want to get into the facts of either of your cases. I just wanted to know, and maybe Ms. Wood should take over here. If you were saying, hey, I want to resolve at least one of my cases, or if it was, I want to resolve both, and you and Ms. Wood had that discussion about why Mr. Johnson was involved to begin with. In other words, this possible conflict. So why don't you, Ms. Wood, shed a little light on where we are?
Thank you, Judge. So I have spoken with Mr. Conley, and so he has been indicating to me that he's ready for trial on both cases.
Trial, okay.
I advised him in the back this morning that I would like for him to allow me to have more time to talk to Mr. Jordan. I have been talking to Mr. Jordan about his case, but since I have fewer cases today, I have more time to dig into this one with Mr. Jordan. And so that's why I wanted to explain to him what his options were instead of just saying, hey, let's go to trial.
Sure.
And so if he is okay with that, I'm happy to have him wait a little bit longer in the back so that I can speak with Mr. Jordan, and then maybe we'll come up with.
And you'd be speaking with Mr. Jordan about both cases or just the property case?
So what would I have to do to just resolve? Because I'm just like, I'm fed up. I'm trying to be over it.
So what you and Ms. Wood need to do, if you haven't yet, is talk about this thing I just spent 5 minutes talking to you about, which is the conflict, not what the officer said about the criminal damage to property. Not, you guys are going to talk about the facts of the case. You do that in private, but Ms. Wood cannot represent you on the shooting case unless the two of you talk about the conflict. Ms. Wood tells me what the conflict is. I decide that it's waivable, and then you tell me I want to waive it. I'm not worried about that conflict. That doesn't trouble me. I want to try to resolve both these, assuming that it's resolvable. It may be that Mr. Jordan says, sure, 100 years. I'm not going to take 100 years. I'll go to trial. I'll tell you one thing. Ms. Wood is not going to be able to represent you for trial for the shooting case for two reasons. One, we'd really have to dive into that conflict. But two, she's not in a position to try that case yet. She knows a little bit about it, and she certainly could help you through a plea on that, but she couldn't try that. She could try the other one, that the property case, and that may be what we do on Monday if we're not sorting things out. So plan C is I don't really have much to try on Monday. Maybe it's going to be Mr. Beard, but otherwise it could be you. But I'm not encouraging you to try it if you could work it out. What you need to talk about with Ms. Wood is this conflict. Why was Mr. Johnson brought in? And is that something that is waivable and that you're willing to waive? If it is waivable and you're willing to waive, let's talk more. It may be that we could resolve both. And Ms. Wood is able to get with Mr. Jordan to say, hey, let's not just sort out this one, which it sounds like at a minimum, the state's willing to drop to a misdemeanor. But you may be able to sort out the other one. I don't know. Have you spoken with Ms. Wood yet about the conflict situation, or you were focused on the property case?
Yeah, I was more focused on like what was going on with the property case, but
which makes sense because that's the case Ms. Wood has been working with you on.
So Judge, I will speak with him again. I just wanted him to hear from you. So
Sure. Can you tell me, so I can be thinking about it, your understanding of the conflict that required Mr. Johnson to get on board?
Judge, I had checked on it way back when. I'm about to reach out again to like our conflict bureau to just double check.
Okay.
I want to say it was like a witness that we had represented, but I'm not sure if it was the complaining witness.
Okay.
I will double check just right now, Judge.
Got it. Mr. Jordan, I know you weren't involved way back then, but do you have an understanding of why there was a conflict?
I I do not, Your Honor, only speculation.
Okay.
The victim may have been represented or something.
All right, Mr. Conley, we will talk at least one more time today to figure out we're going to trial on Monday, or are we working out at least the property case, or are we working out both? Okay? All right.
For right now.
Hi there.
I'm sorry. Could we talk more here before we go back down?
He's not going back down. He's staying up, because Ms. Wood's going to talk to him more.
Okay.
Yeah.
He was trying to get his life together before he got locked up the second time.
Okay.
He was working and everything.
Good. Well, that may be something that Mr. Jordan wants to hear, but Mr. Conley will come out at least one more time, either because we're working everything out or for us to make a plan as to how we're moving forward with the two cases. Okay?
You all right? Excuse, please.
Yes, sir. You did whatever you needed to do back in chambers? All right.
Your Honor, I just saw Attorney Byrne, but we were finished with our discussion about Mr. James.
And are we maintaining it'll go on the 23rd if it's not sorted out?
Yes, Your Honor. We're still in active negotiations with the case, but it seems like it may be better to just keep it on the 23rd as we're a little bit far apart in negotiations. Right?
Okay, but you understand that that is for now first out on the 23rd.
Yes, Your Honor.
Okay, and you're ready.
Yes, Your Honor. The slate's ready.
The one thing we would need to do is just work through the suppression issue.
Yes, Your Honor.
Okay. So Mr. Byrne, Mr. Jordan just shared with me that things aren't sorting out today. You know, Mr. James is first out with your case on the 23rd. I know there's a suppression issue we need to work through if you further particularize your suppression motion. I also know you'll be tied up part of that week of the 17th with Judge Boulay, but we'll be checking in with everyone as to whether maybe that Friday things are sorting out.
That's exactly correct.
Excellent.
I'll send you a particularized motion to really focus on the issue.
Great. And include the affidavit with it?
Yes.
Yes, thank you. So any update from Mr. Jones? Okay, that's okay. How about Ms. Feely? Did you have a chance to talk, get to that case on Ms. Jones's case with Ms. Charles?
This case is one that, she doesn't have a record. There's for a lot of reasons, it's gonna be a diversion referral.
Okay. Yes.
I'm Terry Durham. I'm speaking to the victim, seeking out the foster of the dynamics of the relationship between the victim and spending his background. We believe that is a good case for diversion and also to have diversion with the section.
Okay, so if your office's diversion program says no, thank you for whatever reason, that doesn't change the outcome. It would then just be a similar program.
She also came to something on her end, so that's tailored to her situation.
What is a good deadline to put on that?
It's not 23rd. I think that is sooner than that, when she's also that.
Okay, we'll say by the 23rd. All right, and Ms. Feely, you'll explain to Ms. Jones what all this means. All right. So Ms. Feely, I understand how long you think Mr. Beard's case would take. But if I throw caution to the wind and we start on Monday, you're ready on Monday?
We are ready on Monday. We did lose a juror over the weekend in my last trial, so I'm kind of sensitive about that with the holiday. but-
Yeah, no, me too. It's complicated. But I want to use the trial week. I don't know what else we've got because of YSL.
Judge, we can, I can be ready on position 29, Anna, to resolve this dislocated finger case.
Oh, if it's not a plea?
Yes.
Okay, Mr. Hannah should still be here. Good. So my litigation manager just went back to try to reach Mr. Jones. Have you tried reaching Mr. Jones?
Yes, I did.
What did he say?
I didn't prove so.
Okay,
I've also emailed him.
all right. But you'd be ready on Monday.
I can be ready.
Okay. I take it you didn't write the indictment? Okay. Wasn't, I came on.
So we following that on the.
I don't believe that. Version of insurance today. Yeah. And I think there's a full.
So we get certified today.
Certain issues on the marijuana.
Okay.
Ms. Feely, if, and I need to think about it again. It's been a minute. So I'm not asking this because I'm leaning one way or the other, but Mr. Bright, if the motion is denied, I know Ms. Olivier was saying, ooh, soft maybe in June, but when would you be ready?
I'm ready on that.
You're ready. Okay. It wouldn't be Monday, to be clear. It wouldn't be the 9th, but you're ready to go. Okay. I know he's ready. Mr. Abate, how long has Ms. Olivier been in your unit?
She started.
Where is she? Did she come from the trial division? Did she come from another county? Cobb County.
She worked in Clayton prior to that. She worked. She helped with the med operating or med operation.
Judge, Ms. Healy's showing Mr. Dill the surveillance video now on my computer.
Oh, how long is it?
30 seconds.
Oh, great. Okay.
And once that's done, I was wondering if I could be excused to Judge Dunaway while we wait for Mr. Jenkins.
Yes. Let me see if we. Okay, so Mr. Hanna and Ms. Nelson are having the same success reaching Mr. Jones. So not even support staff. I'm not going to make Mr. Hanna wait around forever. I think we'll probably go forward with Mr. Beard on Monday. I don't want to keep you in limbo, but I'll need to circle around and I'll certainly let you know. Obviously, we have to let Mr. Jones know, although it sounds like saying we're going to start with Mr. Hanna might yield a plea to the dislocated finger case. Fortunately, Mr. Hanna's out, so we're not burning his time in custody while we can't track down his lawyer. Yes, once Mr. Dill is done watching that, you should go to Judge Dunaway. I think we still need you, though, for Ms. Wood to talk to Mr. Parker. Oh, that's Ms. Charles's case?
Yes.
Excellent. All right, then.
Talking, if there are signs of sexual assault.
Okay, all right. Yes, you should go where you need to be, and then we'll just get that email out soon.
Thank you.
Is there anyone here whose case we haven't talked about? Yes. I was gonna ask, it came off my calendar. You're Mr. Kilpatrick? Yeah, because I had on here, there was gonna be a plea for Clifton Kilpatrick. As in just on the computer, you put it on there and then it disappeared. I don't know. Okay, but it's good he's here. Ms. Feely's your lawyer?
Yes, sir.
Okay, don't go anywhere. Do you, that's a special, that might be Shapiro? Okay. When you're done, assuming it worked, I don't know if that cone is a bad sign, Mr. Kilpatrick is here.
Yes, that, we are putting the final touches on a negotiation.
And you need which prosecutor?
Ms. Charles.
Ms. Charles. Oh, good. She's around. Excellent. I'm going to go deliver an adoption order to the clerk's office because those have to be hand delivered. It seems like we got works in progress, but then I'll come back. We can take Mr. Kilpatrick's plea. Mr. Dill has seen what he needs to see.
Yes, and I need to discuss that with him privately, so I'm done with him for now. For today.
Okay, so he can go down. You have green lighted not prioritizing Dill because of the state's witnesses situation. Right. Okay, I don't know that post-birth will delay it, but you can let the witness know I won't be bothering her during the course of this trial calendar.
Yes, sir, I'll do that.
Thanks, and thank you for making the video available.
Yes, sir, thank you. May I be seated?
Yep.
Thank you.
All right, so I will come back after I deliver that. And we'll do Mr. Kilpatrick when you get an update on Mr. Parker. Mr. Hannah, I'm gonna have you stick around a little bit longer just in case someone gets a call back. But then I'm gonna let you go. It's not on you that he's not here. You don't need to worry. It's not affect your bond. Okay?
Can I go to Judge Fernando's courtroom for status that we're having before they start your?
Yeah, what's he's doing on other cases?
That Robert Aaron loan, the stock, over that, he's doing a status today.
Oh, okay. He kept that too. Yes, you may. You're still here just because.
Brandon, wait.
Oh, right. We're waiting because he should be here in about, yeah, go do that and we'll make him wait for you. Yeah.
It's what? That's an understatement for me. As much as I can. It's because you used to being at home. You gotta look awesome. Yes. So nice. Not what you need, right? No. Doing stuff. Y'all call me out. You still in the yeah. Okay, so. First. Because whichever. Yes,
We need
normally does.
Oh, okay.
That just did.
I'm broke. Martin Luther King was on. The week that he's on. He's off that week. Well, he's going to that.
Get back to look like. Mommy chose. What a judge, though.
He's on a break right now. He's coming right back.
But yeah, I had to charge it on my phone.
I have a question now. Due to the fact that Raheem was blended out on one of his charges already, why do he have to re-blend out on?
I'm not sure. I can't fully talk to you about the specifics of this case, but I'm sure this lawyer will be able to answer that question.
He didn't know.
I got you. I'm sorry. I wish I could tell you more.
I got one more question. What kind of TV is it for just in case he go to trial? Not usually don't.
Let me go to trial today. I think we would do it Monday if he did decide to go to trial. But I think you're safe to hold on to that today, but you may want to ask the judge, just to be sure. Because I don't want to give you the wrong information.
So we have to bring it Monday.
If he goes to trial, he may not go to trial.
is 10-03-19. And that's it for everything that I have.
Perfect, thank you so much.
That female is up, whoever is.
Oh, is that the one that Kay needs?
Oh, yeah. She's, went back to her office, but she said 5 minutes.
Oh, okay.
10 minutes ago.
Well, Gordon got a key anyway, but I was like, listen.
Oh, nice. So. There's nothing. No. Is Lauren still here?
Yes, she's in.
Look at the other one, evidence.com.
No, he just tried to send it to me again. That's gonna pull that up. Access. Which is probably-
Wait, what?
And then she clarified, all of this. Oh my God, it's not interesting. This is my Johnson.
Yeah.
Speaking.
You ready?
Let me get some information from you actually.
Which files to remove. Yes. Good. How are you? Happy New Year.
So,
There, your girl. Oh, my bad. I printed off the case memo. I thought I printed the TP. Oh, we'll get back to you.
Yeah, just give it to me.
Send you.
So I can just.
Let show it. See, Jason.
Okay.
The confirmed dates or something. Perfect.
Okay.
Okay. No, I couldn't.
Oh.
It's just.
Yeah.
It's not.
She just said that.
I know, I saw it.
Okay.
It's out there.
Got it.
Charles is in the back speaking with a witness, and so we need her for my, but otherwise, yes.
Oh, here's Mr. Jones.
Hi, guys.
Thanks for coming.
Yeah, I was in the phone jail when I got the message.
Well, that's good. I appreciate you coming. Glad I was able to track you down.
Well, apologize to the court for not being in.
Oh, he'd rather see you than the suit.
Got it.
Oh, I think we might be waiting on the charger.
Okay,
Mr. Adams is coming, right?
Yes, yes.
Okay. Yeah, so that's all right. Okay, no, you're fine.
Five years to serve one, reduce the time served. No contact with the victim. I thought so. Yeah. When I tried to go there.
He's got a new place. Yeah. Oh.
How you doing? Jordan. How you doing? So I got Jared Hannah. Okay. You know, I don't have my file. So I didn't think it was on this morning. Before you get too far, I think that's John Wooden. That's right, it is John. Did he come back?
You want me to reach out to him? You want me to reach out to John?
Yes, please.
Okay.
Okay, and so, do you have, those kind of things? I think you sent me an email, reach out. I think you just called me Mr. Adams. I'm not. I'm still waiting. It's good. Okay, now it's okay.
I was looking at that. Yes, that's it.
No. That's what it's not. What was that? Oh. No way. Okay.
Oh, no. What incident? What day did it from? Oh, my gosh.
So you just got out. I missed you that day. Alright.
You didn't answer, can you text him?
Sure, absolutely.
Okay, thank you.
Judge will have time for one plea before he has to leave the bench, and then we'll have to come back this afternoon, so. If anybody's ready.
We're ready. You know,
We're ready.
Okay.
What do you got? Oh.
Will you let Mike White and her know that, Mr. Jordan?
Yes, I did.
They got one plea he can take before he has to leave the bench?
I'll text them that as well.
Okay, thank you.
And then what time will we come back?
2:30.
Yeah.
There.
Lenore, did he respond? Did he respond?
88 Wettenauer didn't respond to either. of the
You know where
texts.
he went?
I don't know exactly where he went. I'll step out and give him a call.
Okay, thank you so much.
He didn't pick up. I'll send him an email as well, but he didn't pick up the phone call. You said you need to speak to them before you confirm.
No, I think you pretty much have it.
Okay.
Just want to confirm.
Okay.
Hey, John, this is teacher Nelson. I'm trying to get hold of you to see if.
Oh, okay.
He said he's in another courtroom and he won't be able to make it until we reconvene.
When will we do that?
2:30.
So can we be excused until then?
Yes. You have anything else, Ms. Wood, Ms. Eve?
Kilpatrick's plea.
Are you ready for that?
Yes, but Ms. Charles is in the back still.
Want to let her know that you can take one more plea before, otherwise 2:30. You want to say 2:30? I don't know, can you do a plea in 20 minutes, 30 minutes?
Absolutely.
Some speed reading.
Just know Ms. Charles. Thank you.
I mean, and if not, we can just do it in 2:30.
And I need, I'll email you. I'm sorry.
It's gonna be a little while, so unfortunately we will have to come back at 2:30.
Okay, I'll let them know. Anything else you need to announce?
I just need to make an announcement on position 25.
Oh, is that?
Mr. Parker.
That gonna be good?
So not today, Ms. Charles and I are still working on that one, but Mr. Parker let me know he's gotta go pick up his child at 12:30. And so this case is already on the January 23rd supplemental calendar. So I was just wondering if he could be excused and we leave it on there, and then if I can work something out, I'll email you.
Let's see what.
Okay, thank you. I don't know if I got more comments. I forgot about the Google situation.
Gotcha.
I'll keep you posted.
Okay, thank you so much.
Thank you. Okay.
I didn't excuse me, but I didn't respond to her email, but she said, she was questioning, she says, oh, they're on both calendars, being here to I'll be out of town this, but I didn't excuse me.
Hey, folks, sorry for the casual attire. Let's just talk about what we're gonna do now versus after. I have unfortunately back-to-back meetings at 12:15 and then one right after it. My understanding is that Mr. Conley, I don't have an understanding on Mr. Conley. Don't bring anyone out quite yet.
Excuse me, it's the prosecutor back there, is you out here?
Oh, who's it back there? Oh, she's back there? Is there also a defense attorney back? Oh, no, Ms. Price is up, probably. She can stay back there. They can be productive. Thank you, though, for flagging that. Mr. Conley.
Judge, I don't have an update just yet. That one's next on my list. There was another wrinkle that came up on that one, but I'm gonna call a supervisor.
Okay, so it's one you want to keep working on.
I do.
Okay, so you all, no, you're Mr. Parker. Mr. Conley's sister has been circulating. They should go have lunch or not come back, however they want to work it. But I'm happy to still interact with you and Mr. Conley and Mr. Jordan later today.
Okay, thank you, Judge. I'll let them know if they're in the call.
Okay. Mr. Adams isn't here yet, I guess. Oh, that's the one update I didn't get. That's Mr. Way, Mr. Avery, Mr. Jenkins, we covered, Mr. Dill, we covered. We'll get a lawyer for Smith and Greer. Mr. Horton, his lawyer had an excuse to not be here. Mr. Horton did not. So still, no, not Horton, Gibson. Horton, you were going to try to find.
I did not make, or I was unable to make good contact.
All right, so we'll do bench warrant for Horton and Gibson. They may both end up being walk-ins. I think Ms. Griggs thought because she didn't have to be here, her client, and that's on the 23rd. And so she was thinking, well, I'll just be here on the 23rd. But today you're supposed to be here too. So we'll do bench warrants for Gibson and Horton. That's all I got. So what did you want to talk about? Oh, and then there's Mr. Parker,
Yes,
right?
Mr. Parker's case. Mr. Charles and I are still working on this one. Mr. Parker, let me know, he needs to leave.
Pick up a kid.
Yes.
Yes,
And so I do believe he is on the 23rd.
he is,
calendar.
position 4.
So I was just gonna request that we leave him there and then hopefully I can work something out. next
Okay.
week.
Not a problem. Try not to take a plea on the 23rd. Do something before then. And next week, I'm out of pocket a lot. That doesn't mean we couldn't sort it out by, I don't know what other judge would be around, other than Judge Glanville, who will be busy. But just, we'll be bugging you to know what the situation is. Are you trying to structure something akin to what happened with Ms. Jones, or it would be something that I need to be involved with?
We would love something like that, but we're not.
You're not hearing that right now.
Yes.
Okay. So I'm gonna view that as ready on the 23rd.
Yes, sir.
Okay. All right, do you need Mr. Parker to stick around? You know how to reach him?
Yes.
All right, don't be scarce if your lawyer's trying to find you, okay? All right. You're welcome. Go get that kid. Do you have any other announcements for before the break?
No, Your Honor.
Okay, yes, ma'am.
Mr. Wade, I'm sorry, not Mr. Wade, Mr. Adams, I just got off the phone with him, he said he should be here in 15 to 20 minutes.
Okay, yeah, he was in another county. He is working his way here. He's got clients all over the place. Are you here for Mr. Way? Okay. He may get here at just the wrong time, meaning I may have to be getting on my meeting, but then he and I need to talk. And so it's smart for you to wait. He may tell you you can go after that. Mr. Way obviously is not going to work his case out today, given what the charges are. And I don't know if you were in here when the prosecutor mentioned that he's trying to get some ballistics tested. They did, and so that's not Mr. Way's problem and is not a reason for me to delay it. I'm seeing this as a good case to try the week of the 30th. The holdup is that the GBI is under-resourced and overwhelmed. And so unfortunately, there are lots of shootings in Georgia and they are asked statewide to do the ballistics. And this case has been in line, but that is never a defendant's problem, unless it's Mr. Adams saying, no, I want them to do the ballistics because it'll show that it came from this gun and my client had a different gun. Sometimes the ballistics are great news for a defendant. Sometimes they're really bad. So I understand why the state wants to get it, and they are taking the extraordinary step of saying, we give up on you, GBI, we're gonna just use a private lab to do it. So they'll use the very same science, it's just that you and I have to pay for it because the DA's office has to pay for it. The GBI also pay for it, but that's their job to do.
So will he actually have an actual trial date or a hearing?
Well, what I'm going to tell, I need to hear from Mr. Adams, and he may share something with you that's like, nope, we shouldn't be ready yet. But my view is, tentative view, is that we would set Mr. Way down for the 30th. You know better than I how many days he's been in jail. And so he needs to resolve this. Either it's a plea or it's a trial. There may not be a happy resolution for him, but he's certainly entitled to that resolution. And it's almost 2 years now. That's not okay. So that's what I plan on telling Mr. Adams, and he needs to tell me he's ready. But I need to have that conversation with him. That will probably be after my 2 meetings. So if you want to go get lunch, you can do that. If Mr. Adams gets here by noon, we can have the conversation, but I've got to be on a Zoom call back in my office at 12:15. And so I can't come out at 12:10 and chat with him. We'd have to do it afterwards. And Mr. Avery, we're talking about the same lawyer. So Mr. Adams is en route from, I think it was Gwinnett County. Yeah, but may not get here till about 12:15, which is just the wrong time because I have to get on a meeting with all the other judges at 12:15, and then have a meeting right after that. So I'll be coming back out here to maybe take some pleas and work on other things and to have a conversation with Mr. Adams about your case. And how are you related to Mr. Way? Okay, and with Mr. Way's fiance, and we'll get Mr. Way out here to hear about it as well. So we'll just let you know, as long as you are in fairly short range. Would it be you or Ms. Olivier? Okay, and you and she have a bunch of cases on here, but it may be that Way is on the 30th. I understand the ballistics issue, but we'll sort through that. It will not be on Monday. Yes, sir.
So you think I can finish time to get the keys out somewhere around 2:30?
Boy, that's a good question. No, but I think you should go get your kids, and I'll chat with Mr. Adams real briefly about your case. Your case isn't going away. You're charged with whatever you're charged with, and Mr. Adams needs to get you a trial or get the charges dismissed or negotiate something on your behalf. The fact that he came in late is not my problem or the prosecution's problem. He's going to need to be ready to rumble in your case. So I'm looking at it, it would be something that we'd probably roll over to the 23rd or the 30th, but he'd need to be ready by then. I'll tell you, if it's a choice for me between trying Mr. Way's case or yours, Mr. Way's is going to go first. He's in custody and has been for a couple of years now. That just means we have to move yours to the next trial calendar, but you're on bond. I know you want to get closure on this, but I got to balance those two things. Yeah, no, I don't want that to, you were here on time, and just Mr. Adams had that other court conflict and maybe didn't let us know about it. So I'm gonna be back out here with him, but it will probably be at 2:30. So you should go, and I'll let you, Mr. Avery, should go, and I'll let him know. He's going to need to confirm that he represents you. That's the one part that makes me nervous, because I've had it happen before where the lawyer comes like, nah, he's talked to me, but I'm not his lawyer yet. Okay.
And Your Honor, I can speak to that because when Attorney Adams reached out to me last week, I didn't see an entry yet, but just checking on Odyssey, it looks like the entry was filed yesterday.
Okay, then it's official. So Mr. Adams does represent you. That means you did pay him, because he doesn't file that entry till the check clears. So I'll talk with him about your case. It won't be substantive. You don't need to worry about that, but we'll just need to understand schedule wise. My guess is, and I'm not speaking for him, I'm hypothesizing, is he'll be fine taking it off this calendar because he's new to the case. He'll probably go, whew. But I'm not going to take it off the calendar. If there's nothing left on the week of the 30th, but your case, that's what we'll try. Okay? You are. You bet.
I'm sorry, Judge, are you saying the day of the 30th or the week of the 30th?
The day of is that Monday is when we would pick a jury. And just to be clear, if the two cases left are Way and Avery, we'd do Way. Assuming Mr. Adams says ready, he has to say ready. The state, it's nice when they say ready, but that's less essential than the defense attorney saying ready. Hopefully by now, he's represented Mr. Way for a minute. Yeah. Okay. All right. See you, Mr. Avery.
Your Honor, I do have one good announcement on the Jenkins case. Couch Park actually sent the video of Justice Bruce sitting here, so I'll make sure to serve that to Ms. Wood today.
Amazing what hey, you're going to need to come to court and smile in the camera will do. Huh. Fantastic. So then Jenkins, was there anything else with Jenkins, or was the surveillance? So it's alive and well for the 23rd. And we're producing him for the 23rd. Skippy. All right. It's a great way to wrap up this morning. So are there folks who are up who can now go? Well, let me ask it a different way. Was there anyone you had wanted to speak to who was downstairs and you didn't get a chance to talk to them?
No, you're right.
Okay.
Conley's my only person after today.
Okay. And that's the only person you need them to keep up.
Yes, sir.
Does Ms. Feely need anyone staying up?
I think she's sent everyone down. I'll double check though, and I can let the sheriff's
I
office
think
know.
she was done, y'all can go up check, she thought she was done.
Okay. And then Kilpatrick, is that still going to be a plea and they're sorting it out? I know he's on bond, but so we'll do Kilpatrick after lunch. We'll see what we're doing with Conley. And that may be it. Okay, good. So let's aim to be back here at 2:30 to pick up with Conley, and Kilpatrick's not your case. That's Miss Charles. Okay. All right. So if someone can let her know 2:30 for that. And so you get a big lunch. All right. You bet. And ma'am, if Mr. Adams, he's going to show up. He's not going to think, hey, the judge isn't here. He's just going to walk in here. You should chat with him and then you can decide. Oh, so is Way back there? Way should stay, please. Way should stay. So Way and Conley should stay up. Otherwise, I think we've covered it. All right, I'll be back.
Let's just go like one, I'll come back.
Okay.
Okay,
Let's do.
thank you. I'll be here. So the other ones can go back?
Other than Way and Conley, is that safe? I don't think we need anyone else.
Cause we took Mr. Johnson, Eric Johnson's people down, we took them down,
Good. Yeah, they can go. So who else is still up?
a couple people. We extra.
Why- If you find out, let's just be extra safe. Way and Conley are up. They should stay up, those two. Who else? You don't know anything.
Yeah, that's it.
Just Way and Conley? Oh, and Price, yeah, so when Ms. Charles is done with Ms. Price, you can send her down, but please keep Way and Conley up. And Way's lawyer may be showing up in the middle of the lunch break. If you can connect them, that would be great. But he should still stay Way, because I'll need to bring him out but we're down till 2:30. Okay? So you can have seconds. Okay, we are good. Are you ready, Ms. Charles?
Yes.
All right, Ms. Rivers, are you ready? This has been reaccused?
It has been, Your Honor.
Got it. So we're moving forward on case 22 SC 185452. This is Clifton Kilpatrick, who is here with his attorney, Ms. Primovic. He was originally indicted in 21 SC 179668, but the case has been I'd call it re-indicted, but it's an accusation. And there it is, charging Mr. Kilpatrick with aggravated assault, false imprisonment, and sexual battery. Mr. Kilpatrick, Ms. Primovic tells me that you're ready to go forward with a plea in the case. Is that correct?
Yes, Your Honor.
Have you had enough time to speak with Ms. Primovic?
Yes, Your Honor, I have.
Okay. In a moment, Ms. Charles will put you under oath. When you're under oath, it's important that you answer Ms. Charles's questions and mine, and we'll both have questions for you truthfully and completely. It is no less important that you let Ms. Primovic or me know if you've got questions. If you don't understand what someone said, or Ms. Primovic told you it's going to go this way and it starts to go that way, call a timeout and make sure that you and Ms. Primovic or you and I or the three of us can talk about it. Will you do that?
Yes, Your Honor.
All right, Ms. Charles.
Thank you, Your Honor. May I briefly confirm with Ms. Primovic? Ms. Philly sent me an email. I want to just confirm that.
Sure.
Mr. Kilpatrick, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Lower your hand. Please state your true, correct, and legal name.
Clifton Nathaniel Kilpatrick.
Are you at this time drinking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone to school?
33 years of age, 10th grade.
Did you say 32 or 33?
33 years of age, Your Honor.
And 10th grade?
Yes, sir.
Thank you.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Mr. Kilpatrick, do you understand that you are being charged with the following offenses in indictment, in accusation 22 SC 185452, count 1, aggravated assault pursuant to OCGA 16521, false imprisonment, count 2, pursuant to OCGA 16541, and count 3, sexual battery misdemeanor pursuant to OCGA 16622(1)(c).
Yes, ma'am, I understand.
Do you understand you have the right to plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you gone over all of the rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this accusation, including any potential defenses?
Yes, I have.
Do you need more time to discuss the case with your attorney?
No, ma'am, I don't.
Are you satisfied with her services?
Yes, I am.
Counsel, do you waive formal written of the indictment?
So waived.
Accusation. Okay. Do you waive any of the defects in the accusation, including with respect to any names?
Yes, ma'am, we do.
Mr. Kilpatrick, do you recall being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants as it relates to these charges. Do you or your attorney know of any outstanding warrants that are related to these charges?
No, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge you're pleading to today?
Yes, ma'am.
For the record, on count 1, the maximum would be 1 to 20 years. The count 2, false imprisonment, the range would be 1 year to 20 years, 10 years. And count 3, sexual battery misdemeanor, maximum would be 12 months. Mr. Kilpatrick, do you understand that this is a negotiated plea of guilty, which means the state will make a recommendation to the court, but the court does not have to accept this recommendation?
Yes, ma'am.
In this case, the state will recommend to the court a total recommendation of 8 years probation with special conditions as follows. First condition, no further contact with victim Alexis Steverson, Steverson.
Yes, ma'am.
Stay away from the incident location, which is 537 Boulevard Northeast, apartment 202, Atlanta, Georgia, 30308.
Okay, I'm going to pause you for a moment because I need to write that down, perhaps. Is there a reason to believe that Ms. Steverson is still associated with that address?
She lives very near. She's since moved, but she lives still in the general apartment complex area.
So why don't we have the stay away be even larger? So I don't know if all of Boulevard makes sense. We'll need to hear from Ms. Primovic about Mr. Kilpatrick's comings and goings, but rather than that specific apartment, maybe it could be, a half-mile radius of, so we'll come back to that. While I reflected on it, wanted to grab that. Okay, so we'll refine the stay away in a minute.
Yes, ma'am.
We'll refine that.
It'll work.
Okay. You must complete as a special condition 250 hours of community service.
You understood?
You must also complete a psychosexual evaluation and follow all recommended treatment.
Yes, ma'am.
You must seek and maintain gainful employment. No alcohol or drugs without a prescription. The 8 years for probation, our recommendation is for count 1, 5 years probation. For count 2, 2 years probation consecutive to count 1, and count 3, 12 months consecutive to count 1.
I'm curious why you structure it that way. I'm not critical, just curious. Why not 8 years probation on counts 1 and 2 and 12 on 3 and run them concurrently? Does it work differently for some reason?
It was just setting it down.
Okay,
Either
great.
way it works. That's just how we had it, just in talking.
Understood.
Because I think at one point when we were noodling the negotiation, whether which charges we're going to include in the accusation, one may have fallen out, but in the end, we kept keeping it.
But the key is, sorry, I didn't mean to speak over you. The key is you're recommending, and it sounds like it's negotiated, 8 years, however it's structured.
Yes, sir.
Okay.
Okay. Mr. Kilpatrick, do you understand that a guilty plea today will be permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this guilty plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Understood.
Are you a US citizen?
Yes, ma'am, I am.
Do you understand that by pleading guilty to a felony today, if you use, receive, possess, or transport a firearm or use a firearm in any crime, you'll be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
I understand, ma'am.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you would give up the following rights? The right to trial by jury,
Yes, I understand.
the right to remain silent and not incriminate yourself,
Yes,
the right
ma'am.
to confront witnesses against you,
Yes, ma'am.
the right to the assistance of counsel hired by you or to court-appointed counsel,
Yes, ma'am.
the right to presumption of innocence,
Yes, ma'am.
The right to testify on your own behalf and to present other evidence.
Yes, ma'am.
The right to subpoena witnesses and compel the production of evidence.
Yes, ma'am.
The right to have the charges against you proved beyond a reasonable doubt.
Yes, ma'am.
And the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Mr. Kilpatrick, has anyone forced, threatened, or promised you to anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Mr. Kilpatrick is pleading guilty, but he'd be doing this in his best legal interest.
Yeah. Yes, ma'am. Yes, ma'am. Yes, ma'am.
We believe the facts could show at trial that he committed any of these offenses. We think the factual basis is there, potentially, but he does not admit guilt to any of the new charges or the old charges.
So, Mr. Kilpatrick, that is an acceptable response. Another phrase we use for it is an offered plea. It's when a defendant says, you know, I don't agree with what you're about to say in terms of what the state thinks the facts are, but it's in my best interest, meaning Mr. Kilpatrick's best interest, to take this deal rather than roll the dice of going to trial. So you are saying, I'm accepting this. I didn't necessarily do everything the state said. I may have done some of it. Maybe I knew Ms. Steverson. Maybe we did get together, but it didn't go out the way you're about to hear about it. But I want to pursue this deal because you've decided, after thinking about it, consulting with your expert attorney, that this is in your best interest. Does that describe your situation?
Yes, sir. Yes, sir, and it does.
Do you understand that it still shows up as a conviction? So even though we're calling this as a best interest plea or an offered plea, if I'm running your criminal history next year because you're applying for a job at McBurney Enterprises, oh, aggravated assault, I don't think I want to hire this guy. It's going to show up as a conviction. It doesn't say, oh, but he didn't really do it, or he says he didn't do it.
I understand.
Okay, great. Then I will let you move forward.
Okay, thank you. Mr. Kilpatrick, how do you plead to the charges in accusation 22 SC 185452, count 1, aggravated assault, count 2, false imprisonment, count 3, misdemeanor sexual battery?
Guilty under offer.
And is this guilty plea really and voluntarily given with full knowledge of all of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, Mr. Kilpatrick's cycle reflects a previous arrest but no previous felony convictions.
How, one cycle?
No, there are 5 prior cycles.
Okay. All right. While we're on that topic, let's confer with Ms. Jackson. Ms. Jackson, good afternoon. Thank you for joining us.
Good afternoon, Your Honor.
Do you have similar information in terms of numbers of cycles?
He does have 5 cycles, Your Honor. The last arrest was August the 12th, 2020 in Clayton County for criminal trespassing. He received a nolo contendory sentence. He's currently on probation in Clayton County for criminal trespassing. That disposition date was July the 12th, 2022, and the term is for 12 months. Nothing in addition, Your Honor.
Thank you. So it sounds like a misdemeanor nolo probated term out of Clayton. Okay. Thank you.
Your Honor, before I go into the factual basis, may I please share my screen?
You may.
We will be asking for first offender, Your Honor. I told the state I don't know if they're opposing it or not, but we will be asking. He's eligible for first offender.
It sounds like it. So that's going to change. If I give you we'll talk about first offender a little bit later, but that thing I said about if I ran your criminal history because you were applying for a job at McBurney Enterprises, if you end up with offender disposition, it may not be something that an employer could see. Okay, but we'll talk about that. Okay. Ms. Charles, when you're ready.
Yes, Your Honor. Your Honor, had the state, this case gone to trial, the state would have expected to show that on March 23rd, 2021, at 537 Boulevard Northeast, apartment 202, Alexis Stevenson, her friend Caressa Hoda, Mr. Kilpatrick, along with two other people who found out later, Sean White and Terry Kilpatrick, were at Alexis's apartment. Prior to coming to the apartment, Alexis and Terry Kilpatrick were hanging out together at her uncle's house.
Is Terry male or female?
Terry's male, Terry's the brother of Clifton Kilpatrick.
Okay.
Now found out. They were hanging out together. They decided to get some.
We've talked about this case a little bit. I mean, there was communication with the other side as well, but this whole brother situation now is ringing a bell. Okay, got it.
And so they were drinking at the uncle's house. They decided to move the party to Alexis' apartment. And Mr. Terry Kilpatrick called Mr. Clifton Kilpatrick and said, hey, you want to come join us? So they're all there together. They got to the apartment roughly around 10:30 that night. According to Ms. Stevenson, they spent the night drinking. And about between 5 and 6 in the morning, she decided she'd had enough. She was drunk. She decided to go into her there's a 1-bedroom apartment. She wanted to go into her bed to sleep. When she left the party, there, as you can see in the living room area, there is a mattress on the floor and a futon. She left her friend, Carissa Hoda, asleep on that futon.
So leaving the party meant literally just going into an adjacent room,
Yes.
not going to another building or another, okay.
So if you look on this photo that I'm showing on the screen, if you look straight ahead, you see a bathroom.
I do.
And there's a doorway. That's the doorway into the bedroom.
The doorway to the left.
Correct.
Okay.
And so straight to the straight shot from the couch, the futon.
Yep.
And the mattress right there. That's what give you the lay of the land of it. And so Alexis is now in her bedroom. According to her, she's been drinking, hanging out, a little bit inebriated. She falls asleep. She recalls then waking up to a presence on top of her. And she didn't immediately open her eyes. She was aware of something over her mouth and that heavy presence on top of her body. And also she was aware of something inside of her primary genital area. She opens her eyes and she immediately recognizes Mr. Kilpatrick on top of her, and there was a pillow over her mouth. She immediately yells out to Mr. Kilpatrick some expletives, pushes him off. He didn't immediately get up. According to Ms. Stevenson, Mr. Kilpatrick replied in her attempt to get him off of her is, you know what this is, you grown.
You grown?
You grown, you know what this is. And Ms. Stevenson said she wanted no parts of what was going on. She had to sort of come to after just lying down, trying to slip off her drinking. And so she pushes him off of him, kicks him away, pushes the pillow away. So if you see in the corner, the pillow lands near the closet door. And that's the pillow she had just was on top of her mouth when she kind of came to. She then rushes out of the bedroom, goes back into the living room. Now she's screaming, and it's now in the hallway between the futon and her bedroom. Miss Hodo gets up from the mattress, joins her right then, and they all have congregated in that area. She's screaming, get out, expletives, get out. Carissa's asking her what happened. She's explained to Carissa what just happened. They push Mr. Kilpatrick out of the house. Speaking to Miss Hodo, she says, while he's leaving the house, he just keeps saying, I didn't do nothing wrong. You grown, you know what this is. She grown, she knows what this is. They proceed to follow him outside, and they now all congregated on the sidewalk.
When we say all, there had been.
And Ms. Stevenson, they follow him. They follow him outside. That is a story that's in the police report.
Okay, but at this point, according to the police report, where's Mr. Kilpatrick's brother?
Mr. Kilpatrick's brother is gone. When officers come on scene, Terry Kilpatrick and the other girl in the house, Sean White, were not on scene.
So we're down to 3, Ms. Hoda, Ms. Stevenson, and Clifton Kilpatrick.
Correct.
Okay.
In her interactions with law enforcement, Ms. Stevenson did not mention the presence of Terry Kilpatrick, neither did Ms. Hodo. The police report reflects that there were 3 people in the house, Clifton, Alexis, and Carissa. In my review of the case prepping for trial last year, there was an officer who was a rookie, and he was not one of the main responding officers. They had asked him to hold the scene while the responding officers, after taking her initial statement when they responded, stepped outside. So he was simply holding the scene. Carissa was the only one in the apartment. Alexis was outside with law enforcement, waiting for the SVU investigator to show up. The officer is standing near the bathroom, Caressa is still in the living room, but she's on her phone at this time. And she's talking to someone. We never were able to find out who that was. But then she started making statements about Sean was gone. Alexis's boyfriend was there, but he's gone. And in her conversation, she's saying Clifton was playing money games. And so when we were able to meet with Ms. Hodo to confirm what she meant by money games, she said during the course of drinking, Mr. Kilpatrick had made some overtures. Whoever was down to do anything, he had some money for them. She said he'd first propositioned her. Ms. Hodo told me she's homosexual lesbian, so she wasn't interested in Mr. Kilpatrick. Actually, she was there with Miss White, and her and Miss White had been on that mattress under the covers, making out and doing what they need to be doing. So she wasn't concerned with Mr. Kilpatrick. As far as she was aware, Mr. Terry Kilpatrick was in the bedroom with Alexis, and Clifton was on the futon by himself. They all kind of dozed off. She then recalls the screaming. When we met with Miss Alexis Stevenson, her story was substantially what's in the police report. When we asked about Terry Kilpatrick, she said they were friends. She hadn't seen him. I said, well, I've learned of his presence. We need to confirm who he is and because if he was in the house, we would have seen or heard something that would help us figure out exactly what happened that night. Based on what Caressa was saying to us, it didn't quite match her account of the events. She gave me some numbers, addresses. We rode around, called, did a TLO, couldn't find Terry Kilpatrick. In our follow-up interviews with Ms. Hodo, getting closer to trial, she then indicated to me that Terry Kilpatrick had been at Ms. Hodo's house just 2 weeks prior with Alexis. When we first met Alexis, she had a baby, 6 months old. She indicated to me the father was someone who she's no longer with and was just someone casual, no relation. In talking to Ms. Hodo, she says, no, Terry Kilpatrick is the daddy. And so on that day, what we decided to do was to go back to Miss Alexis's house, but this time not announce that we were coming. And when we came unannounced, we knocked, we came to the door, you could tell she was, not expecting.
Not happy to see you?
Not happy to see us. We walked in and I said, laid out to her, I said, look, we need to clear this up. It's a little bit messy. I'm not sure what's going on, what happened that night, and getting some facts that are not in the report. And we need to be sure that there's no surprise at trial. While we were in there, myself, an investigator, and my victim witness advocate, we had a rustling in the back and someone sort of frantic movement, but we couldn't tell, we couldn't see or couldn't tell. Alexis started yelling and shouting at us to get out, get out, get out. We tried to calm her down and says, look, it's not about whether he was there or not. It doesn't necessarily change things, but we need to know. She said, if you're not gonna leave, I'm gonna leave. And so she storms away, takes a baby, storms away. We then sort of hung around the apartment for a little bit, trying to figure out what the next steps should be. While we're there, we see Alexis come down the side entrance, and behind Alexis is Terry Kilpatrick, with a baby bag, and Alexis is kind of running quickly to her car, and Terry's kind of skirting the side alley. There's like some shrubbery and kind of following behind us. So I started taking a video of all of that. Prior to all of this unfolding, when we had done the TLO, there was some addresses in Ms. Stevenson's past that matched the addresses in Terry Kilpatrick's TLO. When one of those addresses was her mother, Tanya Wilson's address. We went to Ms. Wilson's house and asked, hey, what's this going on? And help us understand. She indicated to us at that time, she didn't know what Alexis and Terry had going on. She hadn't seen him in a long time. So all of them sort of was masking the presence of Terry. According to Ms. Hodo, prior to the incident with Mr. Clifton Kilpatrick, Ms. Terry and Alexis were engaging in intercourse to the point where they had invited Ms. Hodo to join them. And she had just left the bedroom and pulled the door a little bit, came back to the mattress, joined Sean. And that is when Clifton went towards the back, towards the bathroom. She says when Clifton went towards the bathroom, she heard the shower running. She thought he had got into the shower. And Alexis said when she came to, the pillow over her head, Clifton's with her, and she hears a shower running and the door is shut. So everyone thought Clifton was in the bathroom. However, it turns out he was in her bedroom. And she told, when looking at the photos of the crime scene, she mentioned to him when she went to bed that night, that brown towel there was not there. It was there. She assumes that he came, maybe went to the shower, pretending he was taking a shower, and they're going to slipped into her bedroom, because as you can see, they're very close to each other. She said you can put one foot in the bathroom, one foot in the bedroom. They're so close together. And so There is DNA evidence in this case, however, although it's matched to Clifton Kilpatrick, we were concerned.
I didn't follow the word in between DNA evidence and Clifton. It
yes.
does match to
It does
Clifton?
match to Clifton Kilpatrick.
Does or does not?
It does.
Does, okay.
However, when we learned that there was another possibility that the YSTR testing, and the paternal lines could match to Terry Kilpatrick based on what Caressa has told us, it complicates our posture.
Sure.
And given the fact that Ms. Stevenson's taking great pains to hide the presence of Terry Kilpatrick, we were later able to have a very, very brief conversation with Mr. Kilpatrick after making some progress.
With Terry Kilpatrick?
Yes.
So that was gonna be my question. You have, since all this came to light,
Yes.
interacted briefly with Terry.
Briefly, and it was just, I don't have anything to do with this, don't call me, I don't know what happened, I didn't see anything, I was in the kitchen, is what he said.
Okay.
So all of that to say, yes, Caressa will confirm that she heard Mr. Lindsay screaming, she heard him say, "Get off me," she heard him say, he was on my face, he had a pillow off my face, he tried to rape me. Based on all the facts, we think that going to trial, there is enough to raise reasonable doubt as to what actually happened before the incident, the allegation of money games, which later Ms. Stevenson admitted that there was some talk of that. I'm not sure what Mr. Clifton Kilpatrick's understanding was as to who was down for it or not. Mr. Clifton Kilpatrick did not leave the scene immediately. He sort of stayed there for almost an hour, walking up and down the sidewalk. This election happened right around 8 o'clock. The call to 911 didn't happen until about 9:43. This is an hour and then a 2-hour delay. There wasn't a really good explanation as to why there was that delay. And so, given all of that taken together, we thought the best way to resolve this case, to hold him accountable for what happened, but stopping short of putting the rape charge, was to re-accuse the case with these charges and make the recommendation as we had done prior, as we presented to Your Honor. And then we just ask that you accept the recommendation and follow.
It sounds like Ms. Stevenson's perspective on this is leave me alone.
It was. Later on, we had, with great difficulty, got her mother to talk to her. She and I have had conversations since then. She took my witness advocate. We've explained to her at the time we had to make a decision. She was gone. And this, we had already communicated this offer to the defense, which was accepted. And we explained what the changes would mean for Mr. Clifton Kilpatrick and for her. And we invited her to be here today. She didn't want to be there. She's understanding now, that this is the best outcome given everything that's transpired. And she has no objections, but she wanted to leave her alone, have nothing to do with her. And that's all she really had to say. As long as he stays away from her, she has a baby. She's focused on Kai. His name is Kai. And that is what she will be doing from now on.
Okay. Thank you. That is very thorough. My 3 o'clock call with Mr. Kenner has been canceled. Something came up from Mr. Kenner, so we can keep going. We don't have to stop. We'll do just that. Ms. Charles, did you have a perspective on first offender disposition for Mr. Kilpatrick? He clearly qualifies for it, and I don't believe the 3 offenses, aggravated assault, false imprisonment, or misdemeanor sexual battery, preclude a first offender disposition.
That is correct, Your Honor. On paper, he does qualify. However, given the nature of the offenses, but for some unfortunate turn of circumstances, I think would have had an extremely strong case to take to trial. There are some allegations talking to Ms. Stevenson's mother. Ms. Stevenson, I just want to give you a little bit more background. Ms. Stevenson's mother, Tanya Wilson, is married to Mr. Kilpatrick's uncle. And so they were all related through marriage. So that's what she said her cousin did it. It really wasn't her blood biological cousin, it was cousin through marriage. And she said to me, she's known Clifton all his life practically. And there have been other allegations of inappropriate behavior. And this is not the first time, although there's not been police involved, this is not the first time he's tried it on. And so we would object to first offender being granted, but it's within his discretion.
Okay, thank you. And I already heard from Ms. Jackson, so we've got the criminal history. Ms. Primovic, I'm going to turn it over to you.
Yes, Your Honor, thank you. We appreciate the state in this. This was very difficult, but it could have been tragic for Mr. Kilpatrick if, the jury went the wrong way.
25 years.
To serve no parole, plus potentially. And we met him. He came to our office a number of times. He's very, into his case. He's taken this seriously. He knows the allegations and what this could be all about. He's cordial. He's been very polite and professional to Ms. Feely and myself.
Is Mr. Kilpatrick the client? Ms. Feely had a client who there was something going on in Clayton County and didn't show up, and he had like briefly been arrested. But it was like a family. It was like a paternity kid. Same case. Okay, all right. And then I just want to make sure I'm putting the right pieces in this puzzle and not. Oh no, that's not the right guy. Okay, keep going.
Your Honor, whatever the mother, the allegations that she says, I would just ask you to take that with about 10.5 pounds of salt.
Not just 1 grain.
Not 1 grain,
Okay.
10.5 pounds.
Okay.
I mean, he's 33 years old.
Kill my sodium
None
count.
of his, cycles, his 4 other cycles, have anything to do with sexual behavior. We get a psychosexual to make sure that what we're saying is true. No alcohol, no drugs. He don't even know where his brother is, the brother who is the father of her baby. He doesn't go over to Boulevard. He lives on the West End. He has no business to be on Boulevard, so there's no problem for him to stay away from a half-a-mile radius of the apartment complex on Boulevard. We're asking for first offender, Your Honor. This is a tough situation. He has 2 children, a 13 and a 9-year-old. He got to spend Christmas with his 9-year-old, had a great Christmas. He was very happy with how his holidays went. He has a good job at CKS manufacturer operator out on Fulton Industrial.
I know that well. The bottle maker. We have several folks from Hope Hall who have done well there.
He plans on working on getting his GED so that he could hopefully move up a little bit and be able to buy some nicer things, better things for his 13 and 9-year-old. So we're asking you to accept the state's recommendation, Your Honor, and to grant him the privilege of first offender.
Ms. Charles, I don't think any of these 3 offenses, despite the potential factual basis, would require Mr. Kilpatrick to register. And I'm guessing you structured it partly in that way. Do you agree? Mr. Kilpatrick, is there anything you want to add about any of the things that we've been discussing?
No, Your Honor, everything sounds good. Great.
Well, it doesn't sound great, but you don't want to add anything.
No, sir. One thing. Right, it's not 25.
It's not 25 years to serve.
It is not.
The ankle monitor situation, when this are resolved, how would I go about getting that?
It's a great question, and we'll ask either Deputy Gordon or there's someone from probation is on this call. It comes off is the answer. I just don't know where it comes off. But the terms of your bond end as soon as I sign your final disposition, and then you're going to be given reporting instructions by Ms. Tucson. That's who we have from probation. And then you're going to report, and it'll be soon. It'll be the next few days where you got to go down to the probation office here in Fulton County. Maybe it may be Clayton. We'll figure out what your address is. And then all the conditions we'll talk about with probation kick in, but none of that involves the ankle monitor. So it's coming off. I just don't know if it's today or if it's Monday. I also don't know where you go, but hopefully someone connected to what we're doing today can tell you that.
Okay, great.
All right.
Thank you, Your Honor.
You're welcome. So, Mr. Kilpatrick, I find there's a factual basis for your plea. I understand there's a disagreement. I appreciate Ms. Charles's presentation. It's always helpful to see some visuals so that it's easier to see. Now, wait a minute. If this is really happening, how close is someone who's saying, I didn't know it was happening, or how far away are there? Is there a place where you could have been out of the sight of the others, but with Ms. Steverson to do what is alleged to have happened? So very helpful to see that. Clearly a complicated evening, fueled by whatever you all were putting into your system that evening. And I appreciate the vigor of both sides in saying this is a winnable case from both perspectives. I think the jury would be kind of fascinated by what was going on, but also a little confused as to who was doing what to whom that night. But I do think that a jury could find that you did the three things that are alleged in this case: the aggravated assault, the false imprisonment, keeping Ms. Steverson where she was against her will, and the sexual battery. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, but you've decided after consulting with your two lawyers that this is in your best interest to move forward. And you've already told me that, and that you don't have any questions about anything. I've already asked you that. You said you understand thanks to the help of your lawyer. I'm sentencing you pursuant to what's called the Probation Options Management Act. And all that means is that while you're on probation, which you will be for a while, if you have a small violation, we'll call it technical violation, probation will work through that with you. You don't have to come see me. If it is a more serious violation, you get arrested again, or I get word from Ms. Steverson, and it wouldn't come directly to me, it would go to the prosecution, that you've been texting her, writing her, showing up in her space. That's the kind of thing that would be a serious violation, and that would come before me. I will accept this as an offered plea, as in your best interest. And I am going to sentence you as a first offender. I need to tell you the risks and the benefits, and then I'll explain why I'm doing it as a first offender. The benefit of a first offender is that this is not a conviction. So when you leave today, you will be a first offender probationer. You'll be under sentence, and it's a felony sentence, but it's not a conviction. So if you're trying to get a promotion at CKS or go to another place and you get that questionnaire and it says check the box if you're a felon, don't check it, because you're not. You're a first offender probationer. And that's the benefit, is that you dodge a conviction. The risk, though, Mr. Kilpatrick, and it's a very real risk, and I need to make sure you've thought about it, and you're going to tell me in a minute, is that if I'm misreading this situation and what Ms. Charles was hearing through the grapevine, that you've got some issues that cause you to treat folks the wrong way, and you get arrested again and you're indicted for something serious, and serious would be you putting your hands on anyone in any way that's inappropriate. Not only do you have those new charges, but you'll be back in front of me, and I would have the ability to sentence you to 31 years in prison, 20 for the ag assault, 10 for the false imprisonment, and 12 months for the sexual battery. You've already said you did it through this plea. There wouldn't be another trial. There'd be a hearing. The state would have to prove you violated probation, but only by a preponderance of the evidence, which is a pretty low burden. And if I found that you did, I could not only revoke your probation, but resentence you, take away that first offender status, no trial, and sentence you up to 31 years in prison.